All right, good morning, everyone. My name is Joaquin Esquivel, Chair of the State Water Resources Control Board. Today is Tuesday, February 4th. It is 9:06 a.m., and I'd like to call this meeting to order. I'll begin by introducing my fellow board colleagues. Joining us virtually this morning is Vice Chair Doreen Diadamo and Board Member Nicole Morgan. Here in person with me is Board Member Laurel Firestone and Board Member Sean McGuire. We're also joined by our Executive Director, Eric Oppenheimer, our two Chief Deputies, Jonathan Bishop and Karen Mogus. Our Chief Counsel, rather, is Michael Loffer. Our Clerk of the Board is Courtney Tyler, and assisting her this morning is Margie Ardrell and Susan Reyes. As you can see, this is a hybrid meeting with both virtual and in-person components. If you're joining us virtually, you should be either tuning into the customary webcast on the Cali PA website or YouTube Live. But if you intend on commenting on any of today's items, you need to be on the Zoom platform. There is a link at the top of the agenda and instructions how to get onto the platform. But if you are having any challenges, please do just email the clerk of the board at board.clerk@waterboards.ca.gov, and she can help get you onto the platform. Once you are on the platform, your camera will be off. You'll be on mute until it's your turn to speak on the item you've indicated. For everyone here in the room, good morning. Good to see you. We're here in Sacramento in the California Environmental Protection Agency building. A few announcements for us here as well. Please do observe the exits. If we happen to have an emergency, we'll calmly file out to Cesar Chavez Plaza and await further direction. Also, if you intend on commenting on any of today's items, there is a QR code and a laptop on the side of the room in order to sign up. And once you're at the podium, please do introduce yourself and any affiliation you may be part of. And lastly, please do silence any phones just so that we have an uninterrupted discussion this morning. This morning, before we get into public forum, we'll actually kick off today with a superior accomplishment award, sustained superior accomplishment award that will be presented here by Mr. Greg Gearhart. Invite you up, Mr. Gearhart. Good to see you this morning.
Board for Bev. So first of all, I want to acknowledge Bev Anderson-Abbs, senior environmental scientist who's retiring. You can have that mic if you want. Let's turn that on. So we don't have the actual award, but because of Bev's retirement and timing, we're having this ceremony today. So I appreciate your time and indulgence in this. So Bev has spent, over 10 years at the State Water Board, but has a career of public service. She goes back to working on bank swallows and teaching kids and doing all sorts of other things before she came to the Water Board. But for sure, the last 10 years at the Water Board, Bev has made a dramatic difference in our data infrastructure. A lot of people think about the performance report as the shiny things that are on our web pages that tell us the stories about the work that we do and the resources. But Bev not only did that, but she helped build this amazing new network of data and pipelines that go to these report cards, improving the quality, improving the efficiency, and all that other work. So I really appreciate all of the time and effort that Bev has put into improving the services that we provide. I'm a true believer, if you don't know, in open data as a form of open government. And our performance report lives that value. It really does demonstrate the capacity to not only tell the story, but show your work behind the scenes. And so with Bev's work and her dedication to making it not only a good report, but a good system, we have a much better place for our folks in California and the waters. So thank you, Bev, very much. And here's your imaginary award.
Thank you, Greg. I'd just like to say a couple of things. As Greg mentioned, I've been here at the Water Boards for 10 years now. And the opportunities that I've been presented with while I've been here have just been amazing and an incredible growth experience. When I first started here at the Water Boards, I was in Swamp working on the HABs, the Harmful Algal Bloom program, and just had some amazing people throughout the state to work with, from Karen Taberski in Region 2 and Karen Worcester in Region 3, John Marshak here at the Water Boards. Just it made it so much easier to be able to do the things that we did and get that HABs program up where it's now running, and it's just a beautiful system and gives us a lot of really good information and data. And then I transitioned into the performance reports and spent several years fumbling and trying to figure out what I was doing and where everything was. But again, with the people that were around, working with everyone throughout the state, I had to learn all of the databases and how to connect to them and what everyone's data meant. And we've spent, the last 8 years working on that and getting some really good connections, improving the data quality that we have throughout the water boards. And it's just been an amazing experience. So I'm glad that this is the apex of my career, and I'm ready to move on and start doing fun things and travel and carry on with my life. So thank you, Greg. It has been a good opportunity. I've appreciated the latitude you've given me to run with scissors in many cases, and it's been a great learning experience.
Well, it's been a joy working with you. I should mention that the reason it got done as well as it did is because Bev is an amazing human diplomat as well. So we often even had to call her into projects that weren't related to the performance report to smooth over ruffled feathers with people, because that's really one of her underlying base skills. It's amazing, top notch. So it's been a pleasure working for you, with you, and as your supervisor.
Thank you.
Can I borrow a piece of paper? We'll have an
I'll just say, incredibly well-deserved, Bev. I'm definitely a data evangelist too here, but you're in the trenches and have been. And when I think of the performance report, when I think of the transparency it brings to the institution, and importantly, it's not easy often to be able to really articulate all the work that goes on at the water boards. But you have contributed mightily to that. You're definitely a data diplomat amongst it. And so just thank you for that incredible service. The system that you've set up now around the performance report will definitely continue to live on and grow. And it's an incredible foundation that we're just very fortunate that you've brought to us. So just so well deserved, and just thank you. Much appreciated, Bev. Thank you. Thank you. Yeah, should we do a quick photo?
Yeah.
Okay.
Have a better prop. You Photoshop it. Yeah, I'll put in the award. I'll type in your name. Thank you all.
Thank you.
Thank you again, Bev. And thank you, Greg, for elevating Bev here. And again, retirement, well-deserved. Very fortunate. Okay, now we will move on to public forum, and looking to see, as I pull up my list of folks, if we have any public commenters.
We have one,
Okay, thank
which
you.
is Regina Chicazola, and she is on the Zoom platform.
Thank you, Mr. Lawfer. Ms. Chicazola, please.
Hi, thank you for letting me speak this morning. I'll be very brief to not take much of your time. But I just wanted to really encourage this board to move forward with any processes that are possible to provide protections from the Trinity River at this time. And the reason why is based on several factors, but one of them, the new Trump executive orders on California water. Besides the fact that they're very disturbing, that there's, threats of having the other people take over California's water and take away the rights of this board and other people in the state to decide water issues in order to maximize deliveries, including at times of year they're not needed. But you all are very aware that it's weird politics. But this board does have a lot of power to protect our watersheds, as you know. And we have some concerns that as part of the Bay Delta plan that there's not actually protections for carryover storage in the Trinity River. And we realize the Trinity River isn't the main subject of the Bay Delta plan. However, the Trinity River is diverted into the Bay Delta water systems. And therefore, voluntary agreements and things that happen in the Sacramento side do really impact the river. And we've brought up several times that we feel like under water rights order 90-5, I believe it is, that there's possible protections for temperatures in the Trinity. But I think, and I've heard from the board that maybe there needs to be some separate processes around temperature protections and water rights on the Trinity River side. As you're aware, the Hoopa and Yurok tribes have fishing rights on the Klamath River and water rights on the Trinity River. And right now, because there's no protection for carryover storage during multi-year droughts, the water to protect the salmon are not actually stored. And in the Bay Delta Plan, we are talking about storage issues, but not necessarily for the Trinity side, which leaves us with questions. Will the Trinity River then be diverted to help deal with things like voluntary agreements? And just random assurances that they're not, it doesn't feel like enough. The Trinity River has been used to stop Klamath River fish kills. I think that hopefully after a few years of dam removal, there'll be less issues with temperature-related fish kills in the Klamath. But for now, that water is not only really needed to protect the drinking water for people who live on the Trinity River, but also the salmon in the Trinity River and in the Klamath River. Anyway, so I'll try to be quick, like I said, and then beyond that, I just wanted to encourage this board to do everything possible to protect the salmon at this time where they are really under attack. And, to protect what water is in our river systems, especially in times of year that we have unallocated water, and there's not protections. I think the importance of the Bay Delta Plan is very much shown in the politics of the time. And I just wanted to make sure that this board knows how critically important it is at this time in juncture in history. But the basis of my comments were mainly on this Trinity River issues, and thank you very much.
Thank you as well, Ms. Chigazola. Appreciate your comments here and addressing the board, and definitely do feel the urgency on the Bay Delta Plan and all of these issues. So just thank you. Appreciate your words this morning. Okay, that wraps up public forum, and then now brings us to our first item of board business, which is consideration of the board meeting minutes from January 22nd. Looking to see from my colleagues if there's any adjustment to the meeting minutes, and then otherwise ready for a motion, I believe.
I'll move to adopt.
Second.
Thank you both. Ms. Tyler, can you please call roll call vote?
Board Member Firestone,
Aye.
Board Member McGuire,
Aye.
Board Member Morgan,
Aye.
Vice Chair Diadamo.
Aye.
And Chair Esquivel.
Aye.
Thank you.
Thank you as well. Board meeting minutes are adopted. Next, we are moving on to item number 2, which is the first in our tranche of informational items, and it is around current hydrologic conditions and response. Invite up Ms. Bean, and good to see you this morning. Hello, hello.
All right. Good morning, Chair Esquivel, board members.
Bit of shift in the weather.
Yes, substantially. So I'm going to do a brief current hydrologic update for you today. Next slide, please. We're going to talk about current statewide hydrology, which is changing by the minute, and then talk about the Scott and Shasta rivers, a little bit about groundwater recharge, and then an update on water rights annual reporting. So next slide, please. So this is the total precipitation as of February 1st, which has actually changed even by a day. So when we looked at, these are always a little bit behind when they're posted online, but this is your statewide precipitation, which was at 85% of average for the year as of the 1st of February. And it was up to, I believe, 115% a month before that. So that's a pretty substantial change. We dropped quite a bit. And then on the 2nd, it was up to 90%. So it's ticking up with these storms, which is great to see, but still maintaining that shift where you're getting a lot of the rain clearly up north, and then it tapers off as we go south. So again, digging it a little deeper, if we could go to the next slide, please. Looking at the Sierra precipitation indexes, this is the Northern Sierra. You can see here we're at 114% of average, and this was as of yesterday. And we're following that little dark blue line where it says current 32.2. So if you can mind that right there. I know there's a lot of lines here. We're comparing this to a lot of different water years, you can see. Next slide, please. As we move again, a little bit south, now we're down to 53% of average. And again, it's worth noting that, statewide and then in these different indices, we saw a drop of about 20 to 30 percentage points, really depending on where we are in the various systems. But those are ticking up a bit as we're getting some of the rain. Next slide, please. Okay, and then in the Tulare area, we're at 48%, and you can see down again that little blue line is fairly low. So we're just going to continue to watch to see what happens as these storms continue. Next slide, please. Okay, so looking at our snowpack, again, you can see if you look in the northern area, we're at 101% of normal for the year, and then follows the same pattern as we start moving our way south. We have 64% of normal in the central, and then 46% of normal in the southern area. And if you look statewide, that brings us to a percent of normal as 69%. And if you can bear with me, it was 106% a month ago, which again, it's been very dry. We would expect to see that drop down. It's going to be getting colder as the current storms pass us, and we're really hoping to see quite a bit more snow added to the snowpacks. So when we check back in again next time, hopefully we will see an increase there. Next slide, please. Quickly, just touching on our major reservoirs, they are all at or above average. Next slide. Okay, so jumping into to the regional response for the Scott and Shasta rivers, the readopt emergency regulation did go into effect on the 27th, January 27th, and that is good for 1 year. Right now, the curtailments are suspended on both the Shasta and the Scott. The flows as of 6:30 this morning for the Wairika gauge were 1,950 CFS, and for the Fort Jones gauge, they were 3,750 CFS, so well above the minimum flow requirements for both of those. Noting for the Shasta, the snowpack on February 3rd was 128% of the February 1st. February 1st and 79% of April 1st averages. And then for the Scott, the snowpack was 104% for February 1st and 65% of April 1st average. And just as a reminder, those get tracked a little differently. They look at snow water content, and they do that monthly, I believe. And then you can see that here that through mid to end of December, the adult fish that were counted in both of those rivers are listed here. So Chinook, Coho, and Steelhead. And we are planning on a groundwater local cooperative solutions public meeting in February. It's looking like February 25th in Etna, and more information can be found on our website about that. Next slide, please. So we'll just briefly look at these, the graphs, which you're familiar with. The red line is the emergency minimum flows. The green bars would be precipitation events, and then the blue line would be the flows, in this case, at the Fort Jones gauge, and you can see they are well above the minimum requirement. Next slide, please. And for the Shasta River, we're tracking the Wairika flow gauge. And again, you can see them following the storm events peaking up and then staying above that emergency flow line. Okay, next slide, please. All right, briefly, before we jump into the groundwater recharge temporary permits, I did want to mention before we leave the regional section is there was a request last month to at some point do a Colorado River update. And we have reached out to the Colorado River Board. Chris Harris, who has been here before to speak with you, has retired. And so we're now working with them to find a good time to have somebody come out and do that, looking like sometime in the spring, maybe May-ish is what we're looking at. But we're going to coordinate with them a little bit more and get back to you on that. So for groundwater recharge temporary permits, all applications that we have received have been issued. There have been 6. They're listed here. The bit.ly link at the bottom of this slide allows folks to go and take a look and get the specifics on those temporary permits. But I just want to give note that our team really pushed hard to get those all issued in a timely manner. So very proud of staff for doing that.
Really
Next slide,
appreciate,
please.
really
sorry.
appreciate that note and appreciate the great work I know that folks have been doing to process all those applications. Just wondering if there are any pending at this point, or we see any others from folks, very late here in the season, looking to get in there.
No, we received 6 and we processed 6.
Fantastic. Thank
Yeah.
you.
Next slide, please. Also, there was an executive order issued on the 31st regarding groundwater recharge. And just as a brief overview, it makes it easier for local and regional agencies to use existing laws to maximize groundwater recharge. And this is building on the 2023 executive orders and then the subsequent legislation that supported the use of stormwater flows for groundwater recharge. It also, the executive order ensures Department of Water Resources and other state agencies are taking full advantage of upcoming winter storms. It's worth noting that local agencies or regional agencies who are going to make use of this provision, they have to notify the board within 48 hours that they're going to be doing that. We have not received any notifications as of today. Next slide, please. Okay, and just briefly want to touch on the water rights annual reports. This will be my last topic for the 23-24 water year. Those reports were due a few days ago on February 1st. Also want to note that the late reporting fees for the post-1914 appropriative right holders accrue after 30 days. And I have the table of fees here just as a reminder that depending on the size of the water right and the number of days late determines how much that fee is going to be. So you can take a look in that third column, that 31 to 60 days late, that's going to be the first ones that would accrue. So folks still have some time to get the no late fee in there. But I do want to note that as a whole, 44% of water right holders and claimants have not reported as of February 3rd. So if we go to the next slide, we're going to break that down slightly. So the outstanding water rights, those that have still not reported here, are in blue. And we've broken these down by the type of water right for a couple different reasons. You can see we have federal claims and stock ponds, groundwater recordation, other stock ponds and registrations there at the top. These make up a smaller percentage of the total water rights, maybe about 25% of what we're looking at. And you can see that the compliance, or in this case, the outstanding water rights, varies depending on them, but this breaks it down a little bit. But what I want to focus in on, if you could go to the next slide, please, is next slide, please. Thank you. There we go. Just to take a look here at the riparian and pre-1914 claims and then your post-1914 appropriatives. And those are really the ones we're going to focus in on as we provide information and updates going forward, because they make up the bulk of our water rights. But you can see here that our claims are 54% have not reported, whereas the post-1914s were at about 38%. So there's a shift there, worth noting, because those post-1914s are the ones that are subject to the late fees. And so we'll be, tracking those to see, how that looks and how that applies going forward. I did chat with the reporting team before this presentation, and they noted that we really do receive quite a few more reports in that 30-day window. So we should expect to see these numbers decrease. After that, there'll be a question. So,
Can I ask, do you know off the top of your head where we ended up with the 22-23 water year with folks?
I had a feeling this might be asked, and then I just forgot to look. But I want to say it was at about 33, but I'm hesitant to lean on that. But I don't think it changed dramatically from, we had kind of touched on it. We were seeing a few shifting, but I think it was around that 30%, and again, that was really for all of them. And it does make a difference when you start pulling out. And we haven't even gotten into the volumetric changes within these two, which we will show those as we get a little further along. We can dig into that. It's just so fresh. We haven't had a chance to.
And,
Well, I appreciate these early numbers. Board member.
and kind of along those lines, can you just talk a little bit about how you've communicated the changing fees to water right holders? Part of this is to incentivize and hopefully get them to report more quickly. So are you shared the table of all the different fee penalties that are possible now. Are you communicating that so everyone's as aware as possible of those changes?
We are, but I can't give you the specifics. I'll have to talk to the team a little bit more about the specific measures they've taken. But we had a pretty big public process as we moved forward with adopting the fees. And then we do notify folks when the reporting is due. Notifications go out when they're going to be coming. So that would have been included in there to let them know that that was happening. I do know that there's going to be additional communication for compliance that the team is working right now to communicate with folks that already are late to remind them of these things. But I can dig in and get a little bit more details on that.
Appreciate
For
that.
next
Thank
time,
you.
yeah.
Yeah, that'd be helpful.
I think that might be the last slide for me. Yes. There we go.
Great, really appreciated. We don't have any commenters for this item, so it's just here, us at the dais for any discussion. So looking to fellow board colleagues if they'd like to ask any questions, any requests for this update as well. I know we're here really looking to hopefully continue to see wet weather as the water year progresses, but appreciate the update. And I know appreciated the executive order the governor recently issued, and again, all the processing of the temporary groundwater recharge permits. It's really appreciated.
Sure. If I could, I do have one question. Yeah, I completely agree. I appreciate the expedited processing of the temporary recharge permits. I think one thing that as we go through this process year by year, every year is not a great year for recharge. It kind of depends on hydrology and what opportunities present themselves. So I'm always curious in terms of what do we learn from year to year, and how do we make course corrections and improve the process where it makes sense. And so on this one, I appreciate listing out these permits. One thing that I think we've learned from the past years is that we issue permits, and they could be for a substantial amount of water, but that doesn't always become available and for recharge. And I think it was, oh gosh, 2 years ago, where we saw quite a bit. We issued significant amount of temporary permits in terms of acre feet of water, and the report back showed only a small amount was actually recharged. So I'm interested in tracking this as we go, now that we have these permits out, and it looks like this is all we have for the year. For example, how much water does this look like on paper? And then what do we learn as we go throughout the season in terms of how these opportunities present themselves or don't, depending on how the storms roll in. So just wanted to put a little flag in there. When you come back for future updates, I'll be interested in seeing what we can learn. Thanks.
Yeah, and I know that last year we did have the groundwater recharge team come out and do an update on that. And so I'm sure we could have them do that again when we get to a point where it makes sense.
Yeah, definitely. Thank you, board member. Looking to other fellow board colleagues if they have anything further to add, any discussion? All right, seeing none, then thank you, Ms. Bean. Appreciate the update. That now brings us to item number 3, which is another informational item, an update from our Office of Enforcement. Give a moment for folks to swap out. Morning, good morning.
Good morning, Chair Escobar, members of the board. How are you today?
Well, thank you. Looking forward to this.
Good. Awesome. Well, I really appreciate being here today. Of course, my name is Yvonne West. I'm the Director of the Office of Enforcement here at the State Water Resources Control Board. And I'm going to be providing you a brief update today about some enforcement highlights from 2024 with a focus on our environmental justice related both initiatives and cases. And I'll wrap up at the end with some short summary of some Office of Enforcement program level enforcement goals. So go ahead and go to the next slide. So as you know, the water boards have enforcement authority in a broad range of programs, with our 3 main program areas being water quality, water rights, and drinking water. The Office of Enforcement provides legal and technical support for enforcement across all the water board's program areas, as well as developing statewide enforcement policy and trainings for the water boards. If you can go ahead and click I'm going to start with our water quality goals, but as just a larger overview, in 2024, the water boards imposed approximately $37 million in liability through administrative judgments, orders, administrative and judicial, judgments, orders, and settlements. So this slide contains some of those highlights from the different program areas. And starting with water quality, you'll see that our regional boards, with support from state board offices and divisions, conducted over 5,000 inspections in the water quality program. We issued over 3,000 enforcement actions, including 165 administrative civil liability orders, totaling over $19 million, with $9 million of that funding going to supplemental environmental projects in the communities that were impacted by those violations. Another thing I wanted to highlight in our water quality enforcement program was that the Office of Enforcement conducted 2 full days of virtual water quality enforcement training this year. Experts from the Office of Enforcement's legal and technical staff gave presentations on fundamental topics such as inspection procedures and email best practices, as well as some advanced and emerging topics such as the implications of the recent U.S. Supreme Court decision in Sackett versus the United States, which adopted a narrowing definition of waters of the U.S. This training event also featured speakers from United States Environmental Protection Agency and panel discussions led by our regional board colleagues. Nearly 450 water board staff attended both days of this virtual training. So I see that as one of our highlights for that program this year. Next, I'm going to turn to water rights. As you know, water rights enforcement focuses on obtaining accurate and timely diversion and use data and addressing unauthorized diversion and use in flow-impaired watersheds. The Division of Water Rights, among other accomplishments, issued a number of information orders, over approximately 30, in the Scott and Shasta River watershed, as well as the Clear Lake watershed. The orders numbers here, however, doesn't include a significant number, over 180,000 or so, that were issued as part of the Clear Lake emergency regs, which I believe you've heard about other presentations, so I wasn't going to go into them too much. But the division also issued a number of cease and desist orders and administrative civil liability orders this year. Turning to drinking water, if you could go ahead and click, please. The drinking water program, as you know, enforcement focuses on access to safe, clean, affordable water for all of Californians. The Division of Drinking Water implements both the state and the federal Safe Drinking Water Act. And in addition to thousands of formal enforcement actions brought by the Division of Drinking Water, I wanted to highlight that the Office of Enforcement was involved in 2 unique cases this year in assisting the Division of Drinking Water in 2024. The first case, Big Basin Water Company, I can talk about now. And the second case, City of Calexico, will be highlighted later in my presentation when I talk about cases with an environmental justice nexus. So just briefly to touch on Big Basin Water Company, it wasn't a typical enforcement for us. The Office of Enforcement is just getting to the point where we have some resources to assist the Division of Drinking Water with their mission. And Big Basin Water Company was unique. It involved both our drinking water attorneys and our water quality attorneys because it implicated a privately owned drinking water and wastewater system that was damaged in 2020 by the CZU fires. And it was failing due to, in part to this damage and in part to mismanagement of this privately owned system. The Office of Enforcement provided support, again, to both the Regional Board and the Division of Drinking Water, who, in collaboration with other local county, state, and local agencies, were able to leverage some of the Division of Drinking Water's enforcement tools to have a receiver appointed to the drinking water system, and then voluntarily able to convince the system to go with the same receiver for the wastewater treatment system. And this, in turn, was able to stabilize both the drinking and wastewater systems and provide continued service to this community. So while this was not an EJ environmental justice community or disadvantaged community, it was important. And I believe that the regional board and the state board, Division of Drinking Water, played a crucial role in making sure that service was continued to be provided to this community. If we can go ahead and go to the next slide, I'm going to turn to some of our environmental justice related enforcement initiatives that we spearhead through the Office of Enforcement. The first one I'm going to talk about is our sanitary sewer inspection initiative, and then I'm going to briefly touch on our environmental justice task force and our role in that task force. So, next slide. So I'm going to highlight the sanitary sewer system inspection initiative as an EJ initiative because it involves the use of our available data tools such as CalEnviroScreen to focus compliance inspections on smaller overburdened communities. Conducting these compliance inspections in these communities allows us to identify non-compliance in those communities with the sanitary sewer waste discharge requirements, and subsequent enforcement actions are brought when appropriate to gain compliance in those communities. So the map over here is, of course, from CalEnviroScreen, and it shows our overburdened communities, a percentage of burden kind of throughout the state there. In 2022, the Office of Enforcement Special Investigations Unit, namely in our staff, Jamie Johnson, Jeremy Myers, under Brian Elder, and then now under Thomas Edgars, began this initiative, kind of grew a little bit organically. We had a lot of expertise in the Office of Enforcement on collection system inspections, and we thought about how we were going to bring that to the regional boards and spread that knowledge. And so what was developed, or what we embarked on, was an initiative to go region by region and inspect and do these inspections in these communities, in the EJ or overburdened communities, with assistance and accompaniment by regional board staff. So to accomplish this mission, the unit, specifically Jeremy Myers, developed a prioritization model that pulls and analyzes information from our California Integrated Water Quality System database. The information it pulls looks at performance indicators such as high peak factors, number of spills over 100 miles, spills to surface water, percentage volume recovered from those spills, and age of infrastructure. It then takes these and analyzes these performance indicators to identify potential collection systems of concern. And once that list is generated, it then focuses the list on smaller overburdened communities with populations serving under 20,000 and with a CalEnviroScreen score of over 70. So those more overburdened communities. We use this refined list to coordinate with individual regional boards to finalize a target list of systems for inspection. The final coordinated list often includes other collection systems, which were chosen for inspection based on community concerns and complaints or other regional board interests. If you can go to the next slide, please. This is kind of an overview of how this initiative developed and where we are today. So as I mentioned, starting in 2020, the prioritization model was developed. We were able to conduct a small number of inspections to initiate the initiative in Region 3, which resulted in a notice of violation to that system. And then in 2023, we were able to inspect a larger number of systems across multiple regional boards. So in coordination with Region 3, 4, and 5, we were able to conduct 7 inspections with all of those facilities receiving notices of violation. And then 1 additional inspection in Region 3 and 1 additional in 5 based on other regional board interests. And then in 2014, we see the culmination of the initiative in the highest number of inspections to date. We're doing 15 inspections completed across regions 1, 5, 7, 8, and 9. Out of those inspection efforts, we've seen a number of notices of violations and staff enforcement reports, and we anticipate some additional action in 2025 as a result of those inspections. I just want to highlight a few things. If we can go to the next slide. This is a breakdown of our 2024 inspections, and the intent of this slide is to really just demonstrate how those efforts break down between the different types of inspections, or why the facilities were identified for inspection. And you can kind of see, just based on this breakdown, again, these are just the numbers for 2024. You can see that the efforts are really weighted towards these small overburdened communities. And with 10 of those inspections occurring in those types of communities. And then I also want to highlight that some of the complaint-based inspections also ended up being in overburdened EJ communities. For example, in Region 5, we were able to inspect East Arosi. This was a unique situation because East Arosi isn't currently enrolled in the sanitary sewer waste discharge permit and subject to those requirements, but they are making efforts to come into compliance. And I think the inspection helped further those efforts and also identify what the weaknesses of that system are. Another highlight that was that in Nyland, we were able to do the same inspection and get them re-enrolled in the sanitary sewer waste discharge requirements permit. And they are working on coming into compliance with those permit requirements right now. One thing you might notice if you're looking at the enforcement column on this spreadsheet is you might notice that there are a lot of notices of violation. And I just want to speak to that. Just generally speaking, while notices of violation are an informal enforcement action, they were chosen for this initiative as a primary first step, and they are really the focus at this point. Because at this stage, we want to bring these communities into compliance without adding any additional financial burden to these smaller communities. And these NOVs have proven to be a good tool for agencies to understand their system's deficiencies and to identify how they can improve their program and come into compliance with their WDRs, their waste discharge requirements. So if we can go to the next slide. This is just some highlights from the initiative and where we're headed in 2025. Again, we increased the number of inspections that we were able to complete in 2024. This was through some efficiencies with the program, as well as working and training with regional board staff. Region 9 is currently undertook 2 inspections of their own, and they are planning to conduct 2 more in the near future. We were able to bring a complaint-based inspection in an environmental justice community back into the sanitary sewer waste discharge permits. And so those were really our highlights. And in 2025, we are, again, going to move forward with inspections in Region 2 and 6. And we hope to use our lessons learned to improve the prioritization model for the next round of inspections in smaller overburdened communities, and really work to keep EJ at the forefront of this initiative. Overall, I think our special investigations unit's efforts have led to a significant increase in the number of collection system inspections completed, not only by our office, but also with the regional boards in coordination with the regional boards. And they've proven an example of how environmental justice can be incorporated into our work at the staff level by prioritizing efforts in these communities by leveraging our access to data like the Cal Enviro screen. So we're looking forward to continuing these efforts. And I do also want to note that that data, the Cal Enviro screen data, is used for targeting in other enforcement programs, for example, in Region 9 and Region 4 stormwater. I know they have similar models and they're using those. Next slide, please. I'm going to move on to our Environmental Justice Task Force. The Office of Enforcement represents the water boards in the Environmental Justice Task Force. This is a task force which is a collaboration between US EPA, Cal EPA, and all of the agencies within Cal EPA. And we work together on enforcement and compliance assurance in overburdened communities. The goal of the Environmental Justice Task Force is enforcement engagement that is more transparent, solution-oriented, and responsive to community needs, and more consistent and sustained. So in working to obtain this goal of enhanced, sustained community engagement, the Environmental Justice Task Force works with existing community-led forums that focus on environmental violations, and we're currently working in the pilot communities of Bayview, Hunters Point, Fresno, Kern, and Los Angeles. Our environmental justice liaisons that are assigned to the task force follow up on community complaints. They work across medium, meaning they work whether it's a complaint about air, soil, water, garbage. They work with all of those complaints and various levels of government to seek solutions for the community. They're communicating regularly with the forum's participants regarding their progress and challenges. And these efforts are intended to coordinate and break down government silos and enable speedy mobilization of multi-agency resources to assist these communities. If we go to the next slide, getting into the details of the Environmental Justice Task Force, the Office of Enforcement EJ liaison to the task force is Selena Cole. She represents the water boards for purposes of the task force. She works along with Brian Elder in the office, who is our Office of Enforcement Investigation and Technical Assistance lead. He has an extensive history with the Environmental Justice Task Force program, and together they go into these community meetings. They conduct these inspections. They participate in the Rapid Response Task Force, and they provide transparent information to the communities. So just some of the highlights on this slide. Out of the Rapid Response Task Force, again, this is a multi-agency response to when there's an emergency situation. In 2023, I believe it was, we had a fire at Schnitzer Steel in the Oakland area. We responded with Region 2 as part of the Rapid Response Task Force. And out of those efforts, we have entered into a new, first of its kind, West Oakland Partnership Agreement. And this was recently signed. It is an agreement to engage in ongoing collaborative problem solving with the industry and the community organization West Oakland Environmental Indicators Project. It is joined by US EPA, Cal EPA, Department of Toxic Substance Control, and the State Board and the Regional Board. And we're hoping to see where that goes with this collaborative process to see if we can address the impacts that community is feeling from that facility. The Office of Enforcement, as part of these efforts, attended approximately 7 meetings of these community groups and coordinated and responded to their concerns through information such as activity logs specific to the facilities that were inspected, environmental log books, and then just the community liaison being present and responding directly to the community groups during their meetings. We also conduct enforcement inspections and compliance follow-ups at the facilities of concern. If we can go to the next slide. I'm going to take a few minutes to just highlight a few cases that I feel are examples of the type of work we do related to environmental justice communities and how we handle them in an enforcement context. If we go to the next slide, I'm going to start with our water quality examples. This case isn't a traditional administrative process. This was a judicial action, and it was a longstanding CERCLA case. We were involved, the Office of Enforcement and the LA Regional Board. This litigation was for failure to comply with the Regional Board cleanup orders. We were able to reach an agreement with previous property owners to the site for $9.8 million in settlement. You see this large red square. This shows the site location, and it shows it in Cal EnviroScreen as a disadvantaged community. This is in Compton. And the smaller square has a map of this site. And you can see on that map, there's a blue arrow that shows the down gradient, the way that the groundwater travels and the pollutants from the site travel in the down gradient manner in this area. And you see all of the schools. There's a residential community about 1.5 miles down gradient of this facility. This was an oil recycling facility, and there's a number of concerns with volatile organic compounds, TCE, and other constituents in the groundwater, in the soils. This is a long-standing case in the sense that the Regional Board brought a cleanup and abatement order in 2014. The Office of Enforcement got engaged in mediation discussions in 2017. And just this year, we were able to bring it to a resolution for at least some of the responsible parties. The significance of this settlement and the engagement of the Regional Board was that we were able to ensure that all $9.8 million would be deposited in a trust for soil and groundwater cleanup for this site in this community, to ensure that the money went to the highest, need for cleanup and to help mitigate impacts to this community. So I wanted to identify this. It's not our traditional administrative enforcement, which will be the next case, but I think it really was necessary, and we played a vital role, again, for securing those funds for the purpose that they should be put to, which is that community cleanup, or the cleanup of that site. Going to the next slide. This is an example of more of how environmental justice benefits can be seen through our administrative enforcement actions. This is, again, another Region 4 case, and it's a water quality case against the Los Angeles County Sanitation District. This is a case involving a release of 8.5 million gallons of untreated wastewater into the Dominguez Channel. You can see that fountain of untreated sewage on the top right. There were also 13 other smaller sanitation sewer overflows over the 4 years leading up to this event that were included in the settlement. The settlement includes or allows for $5.9 million of that penalty, that $6 million penalty, to be directed towards a supplemental environmental project in an EJ community. It's a stormwater capture and groundwater recharge project, again, in a historically overburdened community in Callis Park. So this is the attorney part of me. I'm going to say this was just reached, this settlement, and so the project is still in the planning phases, but it is envisioned that it will be a project to capture and pre-treat approximately 13.8 acre feet of stormwater annually, and then infiltrate that stormwater on site to groundwater through bioswales, storage vaults, rain gardens, and infiltration galleries. The project is currently in the planning and design phase, and their hope is that it will be completed by January 2028. It'll include multilingual interpretive signage and displays to help the residents learn about the system and to understand what they can do to improve quality of urban runoff. The park where it is located, where the supplemental environmental project is located, has a disadvantaged community score within the top 25% in CalEnviroscreen, and the track itself, where the park is in the 92nd percentile of the disadvantaged community scale. This is an example, again, of what a more typical administrative enforcement, including a supplemental environmental project, can look like. Under the SEP policy, it allows for up to 100% of the penalty to go towards these types of projects. There is undoubtedly a benefit also to the system in the sense that it reduces the amount of water they'll have to treat during rain events. But I think it's a good example of some of the creative settlement that can happen. If we can go to the next slide and transition to highlight the drinking water case that I mentioned earlier. As I mentioned, the Office of Enforcement is starting to support the Division of Drinking Water in some of the enforcement actions. This was a different and new type of enforcement for both the division and the Office of Enforcement. It was a joint investigation between the Division of Drinking Water and the Attorney General's Office Environmental Justice Bureau. They were investigating the city of Calexico and their shutoff practices during the COVID pandemic. And it determined that customers in the city of Calexico, which is a disadvantaged community, were being subject to illegal water service shutoffs during the pandemic. The investigation led to a joint settlement with the city of Calexico for violations of the Water Shutoff Protection Act, as well as violations of the State Water Board's arrearages program. I'm highlighting this as a beneficial environmental justice settlement because not only did it include $150,000 in penalties to the state board, it also included $200,000 in water conservation programs to benefit the residents and direct credit of over $50,000 to 484 customers who were wrongfully shut off. In addition, the settlement memorializes increased consumer protections for customers under a new compliant shutoff protection plan that the city is obligated to implement. A related action that happened in the last legislative year, SB 3 was passed. SB 3 was passed by the legislature and the government, and it actually extended the shutoff protection plan to smaller systems starting effective August 1st of 2024. This is an area I'm going to highlight in my next slide because it's an area of growth for our office because of the extension of these obligations under the Shutoff Protection Act to these smaller systems is an area where Office Enforcement will be focusing in the future. So if we can go to the next slide. Just going to wrap up on our enforcement goals for 2025. In the water quality program, the Office of Enforcement will be working to address or prevent water quality protection impacts from the Sackett decision, the U.S. Supreme Court Sackett decision. We'll be documenting any impacts that we see from that decision. We'll be working to train staff on how to implement the new narrower definition of waters of the U.S., as well as how to increase our reliance on our state authorities under the Port of Cologne to protect waters of the state from unauthorized discharge and fill violations. In the water rights program, we have worked on drafting with the Division of Water Rights, drafting a water rights enforcement policy, and we'll be coordinating with the division on hopefully the release of a policy for public comment and workshopping in 2025 with the hope of bringing it to the board for consideration and adoption in 2026. And then in the drinking water front, as I had mentioned on my last slide, the Office of Enforcement has gained a few resources to look at Shutoff Protection Act compliance, especially in these smaller systems. We've already received a number of complaints related to shutoffs in disadvantaged in EJ communities through the Environmental Justice Task Force. And we'll be working on developing systems to assess compliance and track compliance, as well as just informing the systems of these new obligations to have a shutoff protection plan in place and to implement it. And so that wraps up my enforcement goals and my presentation that I had for you today. And I'm happy to answer any questions or engage in any discussion.
Thank you very much. Really appreciate the overview here. I know because we're firewalled on individual enforcement actions, we don't often necessarily get as much exposure to the office enforcement as I think sometimes we'd like. But this has been fantastic, and just really appreciate you coming up and being able to provide just a flavor of all the work that's going on. Obviously, our enforcement work is a critical arm of our authorities here. It allows us to make sure there's an even playing field out there and that folks are abiding by the regulations that the board has set out. But I particularly appreciate that, enforcement can be a particularly useful tool for communities that have long been burdened disproportionately by pollution, and ultimately help us kind of refine our tools. It's a big state. We're not over-resourced when it comes to this work. And so it always means we're having to prioritize. And so just really appreciate sharing the thoughts and work of the enforcement office here, and think there's just a lot of opportunity, certainly. Appreciate the note on Sackett. And, so much of what you're having to do, like us all, is just continue to adjust to what is an evolving sort of landscape out there insofar as the scope of our federal partnerships, and definitely means that there'll be a lot more dependence and reliance on our authorities here at the state level to continue to maintain and ensure that communities are protected. So just huge thanks and hats off to you and the team and all the work that I know continues to go on quietly out there in the background. And it was really good to see that synthesis as well of, what total penalties were accumulated last year. And I think it'd be helpful as we have further discussions. And I think this is something that, maybe once or twice a year, we should definitely, touch base, but would be helpful to see, okay, what's the kind of breakdown amongst the violations and the programs that those enforcement actions are coming from. But just having that synthesis here is just really appreciated, and I think helps give folks an understanding, an impression of the work that the office is doing. So just thanks for your leadership. It's not going to notice, Ms. West. Thank you. We do have one commenter, but looking to fellow board colleagues if they have comments of their own. Okay. Let's go ahead then and call up Angelina Cook.
Good morning.
Good morning. Good morning.
My name is Angelina Cook. I am commenting today on behalf of California Sport Fishing Protection Alliance, and I was not sure what this agenda item was necessarily going to entail. So I'm kind of commenting on from more of a generalized standpoint of a member of the general public who has been trying to track California's water law enforcement. And it definitely feels like the enforcement piece is the weak link. Feels like California has all the laws necessary to protect equity and accountability in water use. But there seems to be, when it comes to enforcing the laws, it seems really difficult. I'm coming from a rural perspective, I'm based in McLeod up at the base of Mount Shasta, very concerned about the environmental injustice of salmon decline and degenerating ecosystems. And so I'm just commenting today, really wanting to encourage a more proactive and comprehensive approach to enforcement. I liked what I heard from the presenter about the Environmental Justice Task Force. I certainly understand and agree with the level of community engagement that's required in the kind of overpopulated, often polluted communities. But I want to encourage you to extend that type of community involvement into the rural communities. I think that, excuse me, the more people understand the challenges that the state is facing in maintaining water quality, and the more opportunities for collaborative participation and solution problem solving, I feel like the water board can start to move more to a position of responsibility. Rather, it feels like you're afraid to be the bad cop, and I don't blame you for that. And if you don't want that role, we need more local participation in a continual manner. I participated from going from the integrated regional water management plan to the sustainable groundwater management. It feels like there's a disconnect in continuity. So anyway, I just want to thank you for this opportunity to learn more about the water board's perspective on enforcement, and really let you know that communities want to help you ensure water quality and equity for the state. So thank you.
Thank you, Ms. Cook. I appreciate those points. And sorry that there's sort of a perception that I guess we're not willing to enforce. I think the 40 million in penalties shows that there is a lot of enforcement going on, but it is a big state, and we don't have enough boots on the ground to be everywhere at every time. And so to your point, actually, the public engagement and the public are an important actually continuum of enforcement. And actually, Ms. West, was wondering if you could speak to ways that if folks are seeing something that they're concerned about in their community, pollution or discharge otherwise, is there a place that folks can go to raise to the awareness of the Office of Enforcement any issues that we may be able to help with?
Yeah, of course. I really do appreciate the comments that Ms. Cook brought to the table. It would be great to have engagement in those rural communities as well. Resources are always a constraint, but if you do have concerns, the best way to get them to us is through the Cali EPA complaint portal, which is on their website. It's linked off of our main website. It's linked off of the Office of Enforcement website. It's a little green button that says environmental complaint. And the reason I say that is because that's our best way for tracking it. Because once we get those complaints through that system, we're able to send it not just internally to other Cal EPA agencies. If there is, let's say, an air issue or a toxics issue, we also have it linked into some local agencies as well. We can get it to our local agency partners. And we can track it in the sense that, like, if somebody else gets the same complaint, they can go in and get the same information, and they can benefit from our investigation. So, our phones, of course, are always an option. You can always call us, but we really do encourage folks to use that website and to use that Cal EPA complaint portal. It is a good way for accountability purposes for us to keep track of complaints coming in. We are somewhat reactive in our enforcement program, and so we are trying to triage and handle incoming complaints. And so if your community does have concern, that's always a good way to get attention.
Really appreciate that. Thank you. And again, appreciate the comments, Ms. Cook. And I think that I know, obviously with sort of curtailment work that we're doing up in the Scott and Shasta and other more rural reaches of the state. You know, there has been a little more of a presence, but definitely heard that, I mean, again, it's an incredibly large state, and we're dependent upon the partnerships truly in communities to be as effective as we can with the resources we have. And so do encourage folks to reach out and know that we're here to continue to be not just responsive, but to think ahead as well. And I think that that's where, you know, looking at the shifting landscape and federal involvement, et cetera, is important. You know, we're doing our best to stay on top of what is certainly a complicated time. But again, the work that the office is doing is just incredibly appreciated. Looking to fellow board colleagues, Board Member Firestone.
Yeah, thank you. Thanks for this update and for all the work you all are doing and for highlighting a lot of the EJ work. I feel like there's so much at the water boards that, like the chair said, we don't always see, especially with enforcement being having separation. But you know, there's, as you mentioned, there's also a lot of work going on in some of the other divisions. And so it's hard to get a full overview of, you know, all of the enforcement actions. So Office of Enforcement is obviously the key leadership overall with our enforcement efforts, but there's really, as you mentioned, really important efforts going on within Division of Drinking Water, Division of Water Rights, the regional boards, you know, I'm sure many others. And so it's hard to get that full picture, as the chair was saying. I think, you know, I think we can continue to look at how we can help share that broader view. Because as we heard with the hydrologic update, there's a lot going on just in terms of reporting for water rights, and like you said, on curtailments, and that's really part of an effort to just make our water rights system administrable and functional. So I think that it's important to recognize that, and also just recognize that I, in particular, really appreciate the your and the Office of Enforcement's help in working with the divisions in integrating enforcement approaches and strategies for some of the core enforcement work that they do. So, for example, the Division of Drinking Water does mandatory consolidation authority. I think it's been really helpful to be able to work with Office of Enforcement to continue to evolve and strengthen our ability to do that. And I know, you know, the same is true in many other areas. That's just one example. I wanted to highlight the just, you know, the EJ approach and the sanitary sewer work that you highlighted, and that this the office has undertaken, I think is so exciting and important. I'm really appreciative. I think it's a real example of understanding the importance of, you know, making our systems really work for all of California. So, you know, there's, when I think of overburdened communities, they're often also under-resourced and underserved. And you mentioned some examples, but I know, you know, East Arosi is one that I'm super familiar with, where, you know, there's really a need to look at where are are we under regulating? So are there areas that people are there areas of our state that are not falling under our regulatory program at all, where we need to consider that in adopting regulations? But often they do technically fall within our regulatory programs, but if we're not enforcing and working with them so that they understand that and are held to that, then our programs don't exist in practice. And so all of those protections don't exist. And I think that the work to do the enrollment, you know, fine under enrollment really is about protection and equity and ensuring that our programs work for all Californians. So I just, you know, I'm so excited about that. I think the wastewater needs assessment is also, hand in glove with these efforts in terms of helping us understand where there are underserved communities that and what type of service they have for sanitation and how they fit. So I'm really excited to learn more about how those two are integrating. And I know that staff are working together on that. Two other things I wanted to mention. One is just, we've talked about SEPs and how to ensure that that penalties and resources that are, from pollution or actions that require enforcement in and around underserved communities are actually getting to benefit those communities and EJ communities. And so I know something in our racial equity action plan that we identified was just trying to figure out how can we better resource and identify funding strategies to connect EJ and community-based projects to penalty money, whether it's SEPs or cleanup abatement. And I just am really hopeful that this year we can make some more progress in kind of understanding. I mean, you highlighted some great examples where the system really is working, and Dominguez Channel is a great example. That's almost 100% going to the local community, but often the use of SEPs doesn't work well, and so I think if we can put some work into figuring out how we make that work better, I'm hopeful that we can this year, especially as funding from federal side maybe going down. It's nice to identify how we prioritize the penalty money. So just wanted to call attention to that and look forward to digging in a little bit more and understanding how our SEPs are working and where there's need for improvement or better mechanisms like connection with the cleanup and abatement fund. And lastly, just based on the last commenter and all of our much of our work that is focused on salmon and tribal issues, I just, I think we may want to think as things move forward, how we might have a similar to EJ task force, if we had a kind of similar task force with tribal communities and in relation to, in coordination with the salmon strategy, just for thinking about how we might target enforcement for those areas and improve engagement. Because I think one of the real benefits of the EJ task force has been just improved understanding and awareness of where communities are feeling the most concrete burdens and threats, and under how best to address those issues. And I think there's a lot of work going on and engagement with tribes and on salmon issues, and maybe there's a way that we can use a similar model in the future on that. Thanks.
Thank you, board member, and much in agreement, especially the last point. Board member Morgan.
Thank you. Just really want to thank Ms. West on the update. Office enforcement really does not get the, I don't want to say attention, but the recognition that it really does deserve. There's a lot of great work that does happen, and really want to thank them for the proactive approach of using Cal EnviroScreen. And also, while we do put a lot of focus on the penalties and fines that come in, and while that is a large part of the program, I also want to thank Ms. West for highlighting also the notice of violations. And while the goal is really for communities and our, the regulated community to come into compliance. And so notice of violations is a huge part of that. And you really, I might have missed it, but just curious to just, the number of notice of violations that went out over a year, and then how many of those, how, what was the percentage of resolution that we received just from that first step, from the staff step of just reaching out and letting a community know that, hey, there is a violation, and working with them to bring them back into compliance, and then not going on to more progressive enforcement. Because I think that there is just, it's a great tool to really reaching out and working with the community and not needing to go to those additional steps, and really bringing, I believe a lot of work goes into just that initial step and that initial outreach and communication between our staff and the regulated community, and just helping to understand what is the regulation, what is the violation, and helping to that initial education and helping to comply with our regulations. And so I think, you probably don't have that information right now, Ms. West, but I think maybe for future updates that I would find that information also helpful and useful, because I know that once you do get into the larger investigations and proceeding further down progressive enforcement, that you are really there, more time and energy is spent, and that is yes, definitely interested in those numbers and where you are there, but then also just, how much doesn't have to go that far? How many, how much additional work is really getting put into just that initial phase?
Yeah, I really appreciate that comment. Just one quick response. That is an area where our staff spends a lot of time. I have to hand it to, as Board Member Firestone pointed out, it's not just the Office of Enforcement. We work with every program and across programs, and it is really the enforcement staff in those programs that, in coordination with our office, are doing a lot of that heavy lifting and that assistance, that compliance assistance and communications. And, generally we see, a third of those go on to more formal enforcement from an NOV stage. But a lot of the work does go into that notice of violation stage and that outreach and that compliance assistance. One area that's really good at that is the Division of Water Rights. They do a ton of education every time somebody reaches out to them, because it is a complex system with a lot of rules that are not easily understood quickly. So yeah, I really appreciate that, Board Member Morgan, and I always am looking for that rate and getting it, and you have to break it into individual programs to get it. But I think just on a high level, I'll continue to work on refining those numbers, but it's about a third. About a third keeps going, and the rest of them, we do get compliance, and we do get it at that notice of violation stage from a lot of folks.
Thank you. Really appreciate that, Board Member. And thank you, Ms. West. Looking to other fellow board colleagues. Board Member McGuire.
Yes, thank you so much for the presentation. I'm always in awe of all of the work that your office takes on. I think you're the only one, unless I'm missing somebody, but I think you're the only one that actually represents and works with every other division and regional board at the water boards, which is no small feat. So thank you for that. And I just want to reflect on a couple of the items that you brought up. And the first is on the kind of the goals for 2025. And I noticed you in water rights, you flagged the water rights enforcement policy. And I appreciate that. And I think one of the challenges that we have, and I think we hear this every time we have a hydrologic conditions update, is just about the challenges of getting, as Board Member Firestone mentioned and others, the challenges of getting just reporting to come in a consistent and comprehensive fashion. That's hard. Well, the next step is actually compliance with the water rights themselves. And I think what we've learned through the drought, through the time that I've been on the board, is that it's incredibly difficult to do. And we have over 30,000 water rights in California, and I don't think we have 30,000 staff to pay attention to all of that. So it's really important to have guidance and information out there to set a level understanding of what the expectations are and why when enforcement actions happen, why they happen and what they mean and what those steps are. I know the water rights enforcement policy process has been kind of in the development for a number of years. And I just want to plus up putting that on the calendar. We have a lot going on in water rights right now. I don't think that's any secret. But I think this is just an important tool just for education, for consistency and fairness to all the water right holders that are out there. I think that can go a long way. So thank you for that. And I look forward to more information on that as you move forward. The other area I wanted to highlight is on the sanitary sewer prioritization work. I sit in the sanitary engineer seat on the board, actually. So this is an area of very high interest to me. And we adopted and updated the sanitary sewer general order a couple of years ago. And again, a lot of what we do, so I appreciate the prioritization and focus on environmental justice, overburdened communities. I think that's good. And I think we're learning some from that. And it actually has piqued my curiosity in terms of what else are we learning? I think us board members always have a tendency to ask for more information and more data and so on. And I guess this is no exception. And maybe this is less of an Office of Enforcement ask as to a Division of Water Quality ask in terms of the sanitary sewer order and how that's going, because it does bring to mind where are the gaps in enrollments. Are we seeing a lot? Because you mentioned a couple that haven't enrolled. Are we having challenges with that? And then how is implementation going? And it does bring to mind the wastewater needs assessment and those steps and how all of this funnels together. So I appreciate you bringing this up and flagging those areas. I'm very curious to know what the results of that information show and how we're doing on sanitary sewer overflows. Are we doing better? Are we doing worse? What are we learning? And part of this, both the enforcement actions that you take, informal and formal, as well as the information that we have, all goes to the greater education and awareness of our programs and our permits and the training that's needed and identifying challenges statewide. So I think it's all goes to the greater good, and it's very important to have that information available. So thank you for the reporting. I agree, come back again, I look forward to seeing updates in the future, and thank you for the opportunity.
Yeah, I appreciate that. I'll just respond quickly and tag it as something to come back on. Yeah, I hear former board member Tam Doduk's voice every time I talk about the water rights enforcement policy. I hear her telling me, "You're still working on that?" But on the sanitary sewer waste discharge requirements, our office is working and coordinating with DWQ and identifying folks who haven't refiled under the new permit and working towards getting them into compliance, or determining whether or not they're still subject to it or if they're now not subject to it. We're working through some data issues and hopefully be able to give you some updates on that.
Great, really appreciate it, board member. Yeah, comes to mind certainly that the human right to water also contains a human right to sanitation within it, but it's just trailing certainly a bit when it comes to the emphasis and resources we've been able to apply on the drinking water side. But incredible opportunity right now with the needs assessment and ongoing work to really put a spotlight on sanitation and access. And so really appreciate that. Okay, Vice Chair, was there anything you wanted to add? Okay. Well then, thank you again, Ms. West. I really appreciate the leadership and incredible work of the Office of Enforcement. This has been great, and look forward to, at some time during the year, might be worth coming back, just kind of a mid-year check-in, because there is a lot ongoing, and especially, again, what we're seeing on the federal side, there may be just an increased need to see enforcement from our office. So be worth checking in. So thank you.
Thank you. Thank you very much.
Much appreciated. Thank you, Ms. West. All right, let's go ahead and give ourselves a quick mid-morning break since we have some room here in the schedule. And so we'll give a 10-minute break. We'll come back at 10:40, and then we'll continue on to item number 4, which is a matter before our Administrative Hearings Office. Right, see you all here in 10 minutes after a nice stretch. All right, everyone. Thanks for the break. I think we can come back now. And we are moving on to item number 4, which is now an item before our Administrative Hearings Office regarding a proposed order in the matter of waste and unreasonable use for Marble Mountain Ranch.
Good morning.
Kick it over
Chair.
to Sam. Good morning.
Thank you. Good morning, Chair Esquivel, members of the board. I'm Sam Bivens with the Administrative Hearings Office, and as you mentioned, I'm here to talk about the proposed order in the Marble Mountain Ranch enforcement proceeding. I'm going to talk briefly about how we got here, how this case came to the AHO, the procedural history, our key findings of fact and conclusions of law in the proposed order itself, and then address the comments we've received to date on the proposed order. So first of all, this is an enforcement proceeding that was heard in November 2017 by then board member Moore. It was assigned to the AHO in December 2021 for further proceedings, including but not limited to preparation of a proposed order. In 2023, the parties informed the AHO that there was no need for further hearings or evidence to address changes in conditions since the 2017 hearing. And so we proceeded to prepare the proposed order that's before you today. Under Water Code Section 1114, there are 4 options that you have in dealing with the proposed order that's before you today. One is to adopt it in its entirety, including the change sheet, which is the course of action that we're recommending today. You also have the option to make technical or other minor non-material changes and adopt the proposed order. You can reject and remand the proposed order to us for further proceedings to either develop additional evidence or make more material changes to the proposed order. And then finally, you have the option of simply rejecting the proposed order and developing a new order based solely on evidence that's already in the record. And again, we're recommending that the proposed order be adopted, including the change sheet that was provided last week. Next slide, please. So Marble Mountain Ranch is a guest ranch in Siskiyou County near Soma's Bar. Seems like a very, very nice place if you like outdoor activities and horseback riding and such. It's operated by Douglas and Heidi Cole. And the Coles claim a pre-1914 water right to divert up to 3 CFS and approximately 2,000 acre-feet a year from Stanshaw Creek, which is a tributary to the Klamath River. They use that water for domestic purposes, for irrigation, for hydropower generation, and occasionally for firefighting uses. And I want to make clear that the validity and quantitative scope of the Coles claimed pre-14 right was not at issue in this hearing. We're only talking about whether their use of water is reasonable, whether their method of diversion is reasonable, et cetera. But we're not concerned with either the validity or the scope of that pre-14 right in terms of quantity. So Stanshaw Creek itself, as I mentioned, is a tributary to the Klamath River, and it provides some pretty important habitat functions for listed coho salmon in that watershed. I believe it's the Southern Oregon and Northern California coastal evolutionarily significant unit of coho salmon. And principally what Stanshaw Creek does is provide a thermal refuge for salmon when temperatures get high in the Klamath River. Stanshaw Creek generally, as it connects to the Klamath River, there's a cold water pool that's formed at that connection in all but the driest of conditions. And migrating and juvenile salmon can use that cold water pool to sort of escape the high temperatures that occur in the Klamath River, particularly during the summer months. I'm going to spend a little bit of time talking about the sort of geography and the diversion infrastructure. So if we could have the next slide, please, which has a couple of maps and schematics on it. So the Coles point of diversion on Stanshaw Creek, the actual point of diversion diverts water via a rock dam. There's no real diversion control structure on that dam. The only way to modify the amount of water diverted at the point of diversion is to adjust the stacking of the rocks of the rock dam, and that can be done, as frequently on a daily basis, but not more than a daily basis. If you look at the schematic on the right-hand side of the slide, you can see that the water diverted at the point of diversion on Stanshaw Creek funnels through by gravity through an earthen diversion ditch down to a point of bifurcation. And at the point of bifurcation, the water can go in two directions. It can either go through a 2-inch pipe to a water treatment facility and potable water tanks where the water can be put to domestic use, or it can go to a penstock and into a hydroelectric plant. The tailwater from those hydropower operations can either then be put to some irrigation use, or it goes into a pond at the end of the system. When the pond overflows, that hydropower tailwater is then discharged into Irving Creek, which is another tributary of the Klamath system. I want to focus a little bit on the nature of the hydropower diversions. That was probably the most central issue of the enforcement hearing. The hydropower system is pretty old. It operates using an 18-inch Pelton wheel that needs approximately 2 CFS of water to function. And so you have a kind of a twofold problem here that's related to the lack of a diversion control. One is that water can be diverted into the system that's more than needed for consumptive uses like domestic use and irrigation, but less than is needed to drive the Pelton wheel. And so that water is generally not, that excess water is generally not put to beneficial use. On the flip side, when flows are quite high, that earthen diversion ditch can overtop and slough and have some water quality impacts that were the subject of a regional board, I believe it was Region 1, or maybe it was Region 5, cleanup and accountability order. And again, not only is there that overtopping and sloughing problem with a ditch, but you've got more water coming into the hydropower system than the Pelton wheel can use to generate hydropower. And so again, you have a problem with water not being put to beneficial use. The case was initiated after some complaints in, I believe, 2015 or 2016 about alleging that Marble Mountain Ranch's operations were in some cases dewatering Stanshaw Creek entirely and causing harm to public trust resources. So the prosecution teams, I'll call it a charging document, made, I'll say, 4 critical allegations of unreasonableness. One is the lack of a diversion control. 2 is that the hydropower operations were generally unreasonable, both because of the beneficial use problem I mentioned. The ditch, they alleged issues with the earthen ditch, both from a water quality overtopping perspective and also an allegation that the conveyance losses through that ditch were unreasonable, and that all of these issues caused harm to public trust resources in Stanshaw Creek and the Klamath watershed, principally to endangered coho salmon. One other point to mention, if you look at the map on the left side of the slide, you can see Stanshaw Creek comes down from the right down towards the bottom left. You can see the point of diversion up there at the top right part of the screen, and then there's a marking for the State Highway 96 culvert, which is an important location because that culvert is essentially impassable to fish. So the area of habitat value that we're really talking about, the various experts referred to it as the anadromous reach. It's the reach between the Klamath River, which isn't noted on the map, and that Highway 96 culvert. I think it's less than a mile of stream. And with that, let's move to the next slide. All right, so this, as I mentioned, case came before then Board Member Moore in November of 2017 with 2 hearing issues. They were a little bit longer than this, but I'll reduce them to their essence. One is the past or current diversion or use of water from Stanshaw Creek in Siskiyou County unreasonable. And two, if the diversions were unreasonable, what corrective action should be implemented. And we had a number of parties participate in these hearings. Of course, the prosecution team and respondents, Marble Mountain Ranch and Douglas and Heidi Cole, and then also the Karuk tribe, the National Marine Fisheries Service, California Department of Fish and Wildlife, Old Man River Trust, Conrad Fisher, CSPA, and Klamath River Keeper. Next slide, please. So I'm going to provide an overview of the key findings as set forth in this proposed order. And the first one, I think, is pretty basic. It's that the State Water Board can, of course, consider impacts to public trust resources in assessing the reasonableness of use or the reasonableness of a method of diversion. It turns out that this order, if adopted, will be the first order to make that finding explicit, but I don't think it should come as any surprise based on the general contours of both unreasonable use doctrine and the public trust doctrine. Two, the evidence in the record suggests that Marble Mountain Ranch's consumptive uses are generally not unreasonable. And actually, let me pause there. I want to make something clear, which is when we find on an issue that the prosecution team, when we suggest that the prosecution team hasn't met its burden on a particular issue, that doesn't mean that you're affirmatively finding that that a use is reasonable. It's at most a finding that the use is not unreasonable based on the evidence in the record. That's a fine distinction, but I want to make clear that in adopting this proposed order and the findings therein, you're not necessarily endorsing any particular type of use or method of use. It's strictly an issue of evidentiary burden. So I wanted to make that clear. The hydropower operations, the proposed order finds that they're unreasonable for a couple of reasons. One, that water is frequently diverted but not put to beneficial use for the reasons I described a little earlier in this presentation. And two, that in this system at least, and in this particular set of factual circumstances, the discharges to Irving Creek, rather than returning the hydropower tailwater to Stanshaw Creek, are also not reasonable. That's not a general finding that water from one stream cannot ever be discharged into any other. And the order makes that clear. We're very much limited to the facts of this case here. So the order's directives don't forbid hydropower diversions outright, but they do require that water that's not used by the Coles and Marble Mountain Ranch consumptively be returned to Stanshaw Creek. The proposed order also finds that a diversion control device is needed to ensure that all water that's being diverted is put to beneficial use, and that will also help avoid the overtopping and the water quality impacts from excess diversions that were the subject of the regional board proceeding in order. So, I guess the upshot here is that, we would expect with the implementation of this order that you'd see quite a bit more water in Stanshaw Creek than there has been historically. There are a couple of, say, larger issues on which the proposed order finds that the prosecution team and the other parties did not meet their burden of proof and persuasion. One is on the bypass flow issue. So the National Marine Fisheries Service recommended a 90% bypass flow and a 2.0 CFS minimum bypass in the anadromous reach. There were, I think, two significant problems with that. One is a rule of priority problem. There is at least one, possibly two junior diverters on this system who are not a part of this proceeding. And under the rule of priority in California, before you cut off, and this is general, but before you cut off senior diverters, the other more junior diverters need to be reduce their diversions entirely. Unfortunately, those other parties' diversions were not at issue in this proceeding. We can't, develop a global order for the system based on this record. So as the proposed order lays out, wouldn't be appropriate to impose a bypass flow in this particular procedural context. And the other issue is the amount of evidence and the nature of the evidence supporting the 90% bypass flow recommendation. The 90% flow rate in particular was based almost, at least based on the evidence, entirely on a sort of general presumption in an academic paper by a gentleman named Richter that the loss of cold water is the loss of water is generally bad for the system, and 90% is designed to ensure a quote high level of protection for the system. And there just simply needs to be more evidence and information there in order to bridge the analytical gap between the ultimate bypass flow recommendation and what's actually going on in the system. And I want to highlight footnote 17 of this order, which talks about the kind of information that's ultimately needed to bridge that gap. It doesn't necessarily require comprehensive site-specific studies, but it does require something more than reliance on a presumption for what would be, I think, a uniquely high bypass flow requirement in the state of California. And then on conveyance losses, I won't spend a lot of time talking about conveyance losses, but the evidence suggests that what's observed in terms of conveyance losses is not atypical for the area. And there's a fairly detailed discussion, including some responses to comments received prior to this board meeting on pages 27 through 30 of the order. The next slide, please. So I want to go through some of the comments received, and we received a number of, I had to prepare this PowerPoint before all the comments came in, so I want to highlight some of the other comments as well before we kind of get into the meat of things. First, we received a number of technical and stylistic comments from Alan Lilly, our former presiding officer at the AHO. Many of those are incorporated in the change sheet that's before you, and we thank Mr. Lilly for those comments. Received a comment letter from Margaret Towser, who's I hope I'm pronouncing her name correctly, a retired scientist with NIMS, directed to the bypass flow issue. And then a letter from several signatories from the Karuk tribe and the NGOs that were part of this proceeding, discussing bypass flows, recommending a limitation on the diversion to 0.5 CFS in the summer, requiring that the diversion be piped instead of using the earthen diversion ditch, and then a request that water be shared for fire suppression purposes. Spent a fair amount of time talking about the bypass flows, so I don't want to get further into that unless there are questions. But with respect to the limitation on diversions to 0.5 CFS in the summer, we don't have enough evidence in the record to support that kind of limitation. And then on the sharing of water for fire suppression purposes, a similar issue, not enough evidence to require that. There would potentially be a takings problem under the Fifth Amendment of the Constitution with requiring a private water right holder to share water with other private persons without compensation. And then finally, the evidence in the record does suggest that when there are fire suppression activities going on and water from Stanshot Creek is being used for that purpose, that it's actually the firefighting agencies who are making the call about taking water out of the system and where it should be applied. Mr. Albers and his colleagues also made an attempt to distinguish the El Dorado case regarding the rule of priority on the bypass flow issue. I want to just touch on that briefly. The way they attempted to distinguish that case was by saying, well, in the El Dorado case, the senior user was curtailed entirely, and here the bypass flow wouldn't necessarily entirely curtail Marble Mountain Ranch's diversions, so there's a distinction there. I think that's a distinction without a difference. I think under the general rule of priority in the El Dorado case, any sort of curtailment of a senior user before a junior user is going to be problematic. And there are exceptions and ways to get around that that rule, and those are sort of laid out in the order. But in general, that's at least our understanding of how the rule of priority works. And then finally, we received a number of comments from Mr. Conrad Fisher, who was a party in this proceeding. I mean, he's been fairly zealous in making sure that I receive those comments in terms of emails, and I appreciate that zeal. I want to just be clear for the record that unfortunately I'm not able to respond to those directly due to our ex parte rules. But we certainly received those comments. Mr. Fisher would like to see the order modified to prohibit the diversion of water that doesn't get put to beneficial use, which I think the order effectively does by requiring a diversion control device and insisting that water that's not consumptively used be returned to Stanshot Creek. He and both Marble Mountain Ranch have suggested that it's not technically feasible to install a diversion control device at the point of diversion for a variety of reasons, and suggest that the proposed order require that well, Mr. Fisher suggests this, Marble Mountain Ranch does not. Mr. Fisher suggests that the order require that that the diversion be piped and a further diversion control mechanism be installed at the place of use. The approach of this proposed order is not to be prescriptive about what's required. That may ultimately be a pipe. A pipe can certainly be a type of diversion control mechanism. There may be other ways around that. The order does, as currently written, require the respondents to develop a compliance plan and submit it to the enforcement team. And if there's any disagreements between the enforcement division and the respondents, those disagreements can be resolved by the Deputy Director for the Division of Water Rights. I think there's sufficient flexibility with that compliance plan to allow for a variety of methods of controlling the diversion. But we're suggesting that we not be prescriptive in terms of what those methods are. Mr. Fisher has also suggested, like the other some of the other commenters, that the order require that water be shared for fire protection. I think we've already addressed that, so we'll move on. The respondents had two principal comments. One is that the order is moot because there have been so many changes in the system since the case was heard in 2017. And there have been a number of changes, and one of the most significant ones, and this is detailed in the order, is that the respondents have installed a solar system that will help obviate the need for large hydropower diversions, and they're to, I guess, be commended on making that change. But the order, there are two issues with this mootness argument. One is that they had a chance to tell us that we needed to reopen the evidentiary record to deal with this issue, and they said no, get an order out, just like every other party did. And the other issue is that the hearing issues and the charging document and the hearing itself were aimed both at future potential unreasonable use and also identifying past methods of unreasonable use and diversion. So the order certainly is not moot from my perspective. We had a number of comments on the bypass flow issue. I've talked a little bit about some of the problems with the bypass flow recommendation. A number of commenters raised the issue of water quality and how bypass flows can support water quality issues there. That's something that can certainly be addressed through the compliance plan process and also by the other agencies who participated in this proceeding, who have regulatory authority to require Marble Mountain Ranch to change its operation in other ways. I'm thinking of Fish and Game 1600, et cetera. There's going to be a number of permits that are needed to comply with this order, and those provide avenues for resolving some of these concerns. And then finally, I'll just mention, Water Climate Trust brought up the issue of quantifying what the scope of their right is. and also raised some comments about water quality impacts related to an access road near the point of diversion and the diversion ditch. And again, the issue of, fully quantifying the scope of this right just, isn't before you. It wasn't an issue for the hearing. And then in the access road, I just think there's insufficient evidence in the record to make any particular findings about the impacts on water quality. And I will again highlight that there are other agencies with regulatory authority to address that issue, including a regional board order that is in effect for this diversion. So next slide, please. And with that, that'll conclude my presentation, and I'm happy to answer any questions you may have.
Thank you. Appreciate all the good work that's gone into this and for bringing it before the board here. I don't have any questions outright. I appreciate covering some of, the concerns that Mr. Fisher and others have raised so far as not going far enough here in this order. But look to fellow board colleagues if they do. Vice Chair, please.
Thank you. Yes, I have a question regarding the bypass flows. And Mr. Bevins, I think you did a good job walking us through the order and focusing on the burden of proof and not sufficient evidence, to support additional flows. But as you were, I just didn't think of this when we were briefed on this issue. So would like for you to just spend a little bit of time to talk about where an enforcement proceeding on additional flow that takes into consideration public trust, where that may end, and our other authorities through water quality with respect to in-stream flows would take over. So it just strikes me in looking at that footnote that, maybe it's overly broad in that it gives the impression if the evidence were there that we would necessarily act. But I have, maybe pause on that because I think that there would be a need, if we wanted to go further in this order, that, it should be maybe through a different proceeding with a scientific basis report and in-stream flow studies, et cetera. So if you could please comment on that.
Sure. Well, and hopefully this answers the question. There's a fundamental difference between what you can do under your regulatory authority in terms of establishing in-stream flows for a particular stream or a system, and your authority to do so in an adjudicative proceeding. In an adjudicative proceeding like this one, your decision is limited to the facts and evidence that are presented before you, and your decision needs to follow those facts. It can't go outside that process. There's a very defined hearing process, and eventually the hearing ends. Right, the hearings have to end at some point, and you're required to make a decision based on the evidence before you. Your regulatory authority, I think, can be a little bit more supple and longer lasting in terms of process, more iterative. And so there's a little bit more, at least in my view, flexibility compared to a case like this one where, the parties present evidence and arguments based on what they think things look like. And you're limited to that evidence, and the hearing has to end at some point. Certainly when I was in private practice, hindsight is always 2020. You get through a hearing, you think you put everything out there, and it turns out that the decision maker has other thoughts about things. And if the parties don't want to have a more iterative process like they didn't in this case, it makes it very challenging to develop an evidentiary record for imposing a different type of bypass flow. So certainly there could be, the fact that you're potentially going to adopt an order in this enforcement proceeding doesn't prevent the enforcement division from bringing another enforcement proceeding and developing that evidence. I do think we're going to see quite a bit more water in the Stanshot Creek system if this order is adopted, and so there will be an opportunity to look at that and reevaluate as needed. But yeah, Vice Chair, I think there's quite a bit more flexibility to develop the science via an iterative process through the exercise of your regulatory authority. And that's not to say that adjudicative proceedings don't have their advantages as well. But in terms of developing requirements like this one, there are also some advantages to a more regulatory process.
Thank you.
Thank you, Vice Chair. Board Member Firestone.
Yeah, and I'm probably, on the other end of the spectrum, I think, on these concerns, because I'm concerned that, while we're seeing that we are considering we need to, and we appropriately are considering public trust in our determination of reasonable use. If there's I'm interested with the bypass flow. Is there the potential for, because we are seeing that in consideration of public trust and reasonableness, it's okay to have water skip that mile and be discharged after, there's a gap of when it's taken out and when it's put back in. Isn't it appropriate to be looking at the potential public trust impacts of not having water in that bypass reach, I'll call it, but isn't that part of what we should be considering in terms of public trust? And I think there's a separate, that doesn't determine the whole issue, but I'm just wondering if you can speak to that question.
Excuse me. Well, I think it's certainly appropriate to look at that issue. I have no quarrel with that. I think that's a basic concept. I think the issue is in this on this evidentiary record, do we have sufficient evidence to make findings one way or the other about that issue so that the various uses on the stream can be balanced as the public trust doctrine requires? And unfortunately, we don't. There's evidence in the testimony in the record that keeping water through that part of the stream supports macroinvertebrate life that can be beneficial to salmon downstream. The problem is that there's not particularly concrete evidence beyond that statement about macroinvertebrate life and some water temperature concerns that allow us to, in my view, really evaluate and balance the competing concerns on this stream. And again, that's something that could certainly be looked at through a separate regulatory process, both on this and other streams. But based on the evidence in the record for it, as I view it, we don't quite have enough to get there.
Mm-hmm. Yeah, and there's a lot of balancing and information that goes into determining an in-stream flow, and I think it's I think this order is trying to walk that line. On the other hand, there's a lot of challenges with, as we've seen, we haven't been able to get through in-stream flow regulatory proceeding. And really the tools where we've been able to, or the times we've been able to address it is often through an adjudicatory process. We're kind of never going to have, I think one of the things that footnote 17 does is recognize, like, you don't have to have the perfect study of that site specific. So we're trying to find a balance here, and we're trying to figure out how we can, I think we've seen cases and even in this, I believe in this stream reach and, other parts of the state where you've had the the stream go completely dry. And so shouldn't we be looking at ensuring using our tools to make sure, and our public trust analysis to make sure that a stream isn't entirely dewatered, even if we don't have, I think what I'm hearing is the NIMS recommendation is that the evidence presented isn't enough to determine in this case a bypass flow, especially at the recommended amount. But I'm struggling to, other than saying, well, in theory, you could do a regulatory process, which for us, I mean, we haven't been able to do that for any stream in the state. So that doesn't seem yet. I mean, hopefully we're getting there. I guess phase one was sort of a first step towards that, but of the Bay Delta plan. But we still haven't gotten there, I guess, in terms of an actual regulation, even in that case. And so I'm just wondering how we can ensure that we do have a tool to ensure streams aren't dewatered as we're looking at this. And this is a much broader policy challenge. And so I'm not trying to cram it all on you in this proceeding, but it is kind of exactly what's at issue in terms of, this particular stream and how you're balancing public trust and reasonable use and, lack of science and evidence in a particular proceeding. I guess one question, the thought in my mind was, and I think what I'm hearing from you is that the parties wanted this to move forward, but would it, if the board wanted to, if the board was concerned that public trust wasn't protected, if there was zero bypass flow, then could we pull in, request information, more evidence to come in, and maybe bring more, request more parties to come in? I guess I'm trying to figure out what are our options. Not that we necessarily are going to take that here in this case, but I'd like to understand what our options are beyond saying, in theory, we could do a in-stream flow regulation.
Sure, and there's a lot bound up in that question. So let me see if I can work my way through it, and I'll leave aside the sort of bigger policy implications. That's your guys' job and prerogative, and I'll leave that to you. In terms of if you want to do something like that, so first of all, these adjudicative proceedings can certainly address that issue squarely and more squarely than was done in this case. And as I mentioned, the enforcement division is certainly free to take a look at how things develop if this proposed order is adopted, and bring another case if they need to. And I imagine there will be some lessons learned from this order. I will say that I think it's pretty unlikely, both based on the changes in conditions since 2017 in the last 8 years, and also because of what this order does require, that we'll see Stanshall Creek completely dewatered in that stretch. Possible, but seems unlikely based on what I've seen. So, one option is for the enforcement division to, or other parties to take another look at this, see how things develop, bring another case. Nothing in this order prevents them from doing that. And then, as you mentioned, Board Member Firestone, you do have that option under Water Code Section 1114 to say, no, we're not adopting this. Regardless of what the parties want, go back, have another hearing, and address some discrete issues and revise the order accordingly. We can do that in the short term, but there's also a longer term solution that at least in my personal view will allow this order to take effect and see how things change on the stream, and if they change the way we expect them to based on the evidence that was before us. The prosecution team and others can reevaluate how effective that is.
That's really helpful. And is it in terms of what the options are for for a prosecution team to they'd have to bring a whole new complaint. So say this, after this order is in place, the stream is dewatered again. So then at that point, the prosecutor, or, maybe it's not that bad. Maybe there's just concerns on impact to public trust resources that it's, then the prosecution team would need to bring a whole new case on, at that point to, and, what would the cause of action be?
Well, okay, so one, that's correct in the sense that if they bring a new case, they have to bring a new case. I'll also just highlight that, again, this order does have, a compliance plan provision. The respondents will be developing that compliance plan and submitting it to the prosecution team and maybe potentially to the deputy director for the Division of Water Rights. That process does allow for, a little bit more of an iterative process to address some of these issues. So I want to highlight that as an option. In terms of, what the actual case might look like, I mean, it could be simply just another unreasonable use administrative proceeding before the state board. I would expect it to be a little bit more limited in scope, certainly. But it wouldn't necessarily need to be any different in terms of cause of action than what was brought originally.
And then one more question on this is the, would it help the compliance plan process? Would it help allow the compliance plan process to scope to be able to make a finding here that that dewatering the stream isn't consistent with reasonable use and public trust? And we aren't saying we can still acknowledge that we're not setting a bypass flow here. The quantification of flows is not, part of this scope, but at least put a finding that keeps that as, I think we would all agree, that dewatering a stream isn't reasonable use. And in terms of public trust protection, I guess, I don't think the balance of public trust protection is dewatering the stream. And I wonder if we would, if it would be helpful to put that here in terms of, even though we're not saying we're not determining an exact flow, if that would help a compliance plan discussion be able to address that issue in some way, right? Without establishing an in-stream flow, be able to look at that issue. Because I worry otherwise that, and the compliance plan has nothing to do with flow in that bypass stretch at this point. Otherwise, so question.
Okay, so on the public trust issue in terms of dewatering the stream, I can think of one instance where at least in this case, where you have the stretch of the stream that would be potentially dewatered doesn't have any species of concern actually inhabiting it, or it might be appropriate to dewater the stream, and that's in connection with fire protection. So you could have a situation where there's a significant fire event up there. Flows in the stream are very, very low, and CAL FIRE says, we need to get some water out of here. You have a point of diversion. It's going to dewater that section of the stream for a period of time. That might actually be something where you would want to balance the other way. But again, that's your prerogative. In terms of whether it would be helpful to to make that type of finding about dewatering the stream, that's a question that I'll leave for the board, and it's, your policy prerogative. I will say that to do that, I think that's more than a technical minor non-material change, and you would have to take option C, remand it back, and tell us what you want in there and bring it back to the board. I don't know whether that's helpful or not for what you want to do and where you want to go, but I will say it's an option.
And sorry, just to clarify, those are the super helpful, all of that. If there, without some kind of finding around this, would a compliance plan have within its scope anything related to continued flow on that bypass reach of any kind?
I'm not sure I understand the question in the absence of requiring a bypass flow. It doesn't require any particular bypass flow.
Agreed. Yes. So I'm asking, a compliance plan that required by this order is focused on the things we are requiring.
Yes.
And so I guess my question is there a benefit, or no, not, would the scope of a compliance plan without any kind of finding of even potential unreasonableness exclude discussion and potential actions, management strategies to ensure that the stream isn't entirely dewatered on that bypass stretch?
It wouldn't necessarily exclude those types of discussions at all, for a couple of reasons. One is that the respondents are going to need permits from other agencies to implement their plan, and certainly those permitting agencies like CDFW, like potentially NIMFs, depending on how they want to enforce their regulatory authority, could require things like that as a condition of their permits. So that's I think one issue. Two, just informally, and at least in my experience, and this is my experience in a different career track, not at the state board, but you get these orders, and when you're a water user, you develop compliance plans, and there is sort of a back and forth with the division or the enforcement team about, well, we'd like to see this, and we think this is feasible, and you should investigate that, and so that also provides a more, call it, informal mechanism for addressing those concerns. But I think the big kicker from your perspective is this need for additional permits, and the likelihood that CDFW and potentially others who are going to issue those permits will have opinions about where the water is returned and how it's returned, and make those conditions of the permits they're issuing to get this compliance plan in place.
Okay. I mean, I'm hesitant to just rely on other agencies for, our determination of public trust in terms of flow. But I think where I'm just based on your responses, and I know we've got other people talk, we've got various people that are going to testify or talk, and I think we'll hear more. But it sounds like, especially I think a great example of, maybe if fire fighting is sort of a one-time or hopefully one-time extreme time when maybe it is necessary to dewater. That's I feel like it is a complex issue. I think it is appropriate to say that we didn't, we don't have enough, that wasn't fully scoped and provided in the record to make a determination on it. But I guess I am interested in hearing or hearing thoughts on how we might still flag in this order an area of concern for more discussion and work on ensuring, on recognizing that there's, public trust balancing, which includes, also includes that bypass reach and that, I guess I'm trying to make sure that in the compliance plan discussions, that we're not totally silent on that and just saying there's, the, but that we are flagging that there's public trust considerations and that maybe allows the both our staff and the other agency staffs as who we we have no idea what they'll do, but at least our staff to be able to have that as something that's discussed as part of the different options and management plans and permits going forward. So just that's where my brain is right now. I'm definitely interested in more thoughts on that.
Fair enough. I don't have any suggestions, off the top of my head of how you would do that, how the order would be adjusted to do that at this point. What I can tell you is that procedurally, you'd have to do the reject and remand option I talked about at the top of the presentation. We would.
And would you have to do the reject and remand just for discussion rather than if you're not, assuming that you don't have to do that, I'm assuming that there isn't a finding of, unreasonableness and public trust. So if we don't go that far, but we're adding discussion on this, is that something that requires, I'm looking at Michael Offer.
Yeah. Board Member Firestone, I think what you're hearing from Mr. Bivens, and I think it's a concern I share from the perspective of the Office of Chief Counsel, is that this board is very accustomed to in a proceeding where the board is served as its hearing officer, or one of the board members is served as hearing officer, or in our quasi-legislative matter where the board will often be fine-tuning things at the final adoption meeting. And what you've heard from hearing officer Bivens is that we have a fairly narrow statutory charge here under the Water Code, and that the changes that the board can make when a proposed order comes to the board in this format at the board adoption meeting are limited to minor technical corrections to the order. And the specific language, which I think Sam did a good job of articulating, but I'll read it to the board so you can understand why you're hearing a little bit of hesitation, both from me as well as from the Administrative Hearings Office, is that the board may make technical or other minor changes in the proposed order. And the concern is in injecting a new element into the compliance plan, as grounded as it may be, I think, in the right intention to for a board simple statement along the lines of the importance of maintaining some flow, and that full dewatering could constitute not only an adverse impact on public trust resources, but potentially in and of itself at times be a waste and unreasonable use, requires a little bit more than just a simple statement, and it's more than just a minor technical correction at this point in time.
Yeah, that's helpful. That's really helpful. Okay. This is, I guess, again, I'm, on one hand, I feel like I'd like to help support getting this over the finish line, and I think all the parties want to see this resolved. And I do think it's significant and important for us to also, recognize in writing the appropriateness of consideration of public trust with regard to reasonableness. So I like the, being able to move forward. And I also, am flagging here that this is just such a ripe issue in so many areas before us throughout the state right now that I also want to make sure that we have a chance to consider these things. And maybe it's worth talking in closed session. I don't know, but leave it up to the chair and other board members. And we have more people to hear from. But I'm just flagging, this is an area I think it's worth just being thoughtful how we want to handle and without unnecessarily delaying a ruling on this. So just flagging the issue and interested in hearing more from different folks.
Yeah, thank you for that, board member. I do appreciate the discussion and agree with you that, we definitely need to be seeing this work as, another tool and trying to really establish the floor of in-stream flows in places so that we are being protective. But understand, certainly that the process that we have in front of us with the Administrative Hearings Office is, when these orders are brought to us, doesn't give us as much flexibility here at the dais, but we can still have discussion and appreciate and agree with you that we should be having them. I guess my comment would be, I think the reality is that if this is something and I think, for me, it is as well, something that we want to see greater consideration for in these proceedings coming out of the AHO. It's really working with the prosecution team and others so that we really are setting an expectation that the scope of some of these hearings, when appropriate and possible, is to tackle these issues. And, it's at the start of the proceeding that can be better scoped out. Everyone understands. And, I think there's more options as opposed to, unfortunately, kind of now where we find ourselves in the proceeding. But thank you. I appreciate the discussion and agree. I look forward to hearing from others. We have about 9 commenters, but want to go to Board Member McGuire first.
Yeah, I appreciate all the comments and discussion as well. And so in the interest of brevity, I'm going to ask a kind of related but different question, more of a technical nature. I agree there's a threshold question here about public trust and where that fits into our processes. And so it was good also, though, that we had our enforcement update this morning and talking about priorities and how we can address different initiatives. So this could be an area for further discussion with our office. But my question, Mr. Bivens, is to just clarify when we're talking about in-stream flows. Oops, my phone thinks it's okay. When we're talking about in-stream flows and bypass flows specifically, this is a big deal, adopting this order, and it will resonate not just beyond this particular case, but could be used, as I understand, for other cases, potentially in the future in reference. So when it comes to establishing a bypass flow itself, so setting aside whether we have enough evidence here in this case and all those different factors, which I know you've been very careful in articulating here, I'm wondering if, I think what I heard you say was that we didn't have the authority to establish a bypass flow for this right holder without violating the rule of priority. And what I'm asking is that true in all cases? Because, I know of many water rights that have bypass flows attached to them. And here we have a very senior water right claim, right? A pre-14 right, but nonetheless, it's a water right. And so I'm a little concerned, what I want to be cautious about is putting something in writing that might constrain our tools that we have available in the future if that's not quite accurate. And so I'm hoping you can help me understand that. And again, it may just be my lack of understanding, and that's why I'm asking you the question. So.
Yeah, so to be clear, you do have authority to establish bypass flows as a general matter. I mean, there's no question about that. I don't think the order suggests that. And that's true. It's certainly easier to do, I think, with permitted rights under the Water Commission Act as opposed to pre-14 rights or riparian rights. But even for those types of rights, you have the authority to establish bypass flows. So no question there. I mean, again, as I alluded to sort of the outset, this is a particular adjudicative proceeding with a particular evidentiary record that was developed almost eight years ago, and we're constrained by that record. And in terms of the rule of priority, it's certainly a critical consideration. There are, and we laid this out in the order, and I apologize for not knowing this off the top of my head, but there are certain exceptions that are to the rule of priority that are outlined in the El Dorado case, and those could be addressed in other evidentiary proceedings or regulatory proceedings to see whether bypass flows that would otherwise violate the rule of priority fit within those exceptions. So that's one way around that. And the other way, of course, is to have larger proceedings. For a stream like this, I don't think it would have been particularly taxing to bring everybody else into the case. There's a junior diverter upstream, relatively small diversion, but significantly junior to this one. And then Mr. Fisher also has water right claims, that we didn't fully evaluate, but there's some evidence in the record that suggests that his, or if not junior to, on the riparian side, certainly equal priority to Marble Mountain Ranch's pre-14 right. And if you had everybody in the case, as it were, it would be a lot easier to deal with the priority concerns. So I guess my bottom line is, one, you absolutely have the authority. Two, yes, there are some checks on that authority. There are also some exceptions and ways around those checks. And three, again, we're simply limited to the evidence that's before us and the parties who are in this case in terms of our ability to recommend imposing a bypass flow or not.
Yeah, and Board Member McGuire, the one thing I would say is looking back over the relevant provisions in the order, which on page 24 of the draft order is where the AHO has included a discussion of the EID decision and Justice Roby's discussion of when the rule of priority may be circumvented, for example, to address waste and unreasonable use concerns. And I think the actual manner in which the draft order addresses this issue is pretty narrowly tailored. It's identifying that there are other rights. It would not be insurmountable to convene a proceeding that would address all the rights that are adjacent and are actually junior. And so the language that the draft order uses is that there's not been any kind of showing that it would be infeasible to have a proceeding that incorporates potential bypass flow requirements on those junior users. And so how it actually handles EID and the rule of priority is not in absolutes. Instead, the draft order is pretty much tailored to this specific proceeding and why in this proceeding it does not appear to invoke any of the exceptions that Justice Roby articulated in the EID decision.
Okay. Yeah, thank you for that clarification. I'm, again, trying to track, and I just want to make sure we're not unintentionally putting ourselves in a box when we're talking about these issues of public trust balancing and the need to address flows and streams, that we have all the tools that would normally be available. So thank you for the clarifications. It really does help.
Thank you, Board Member Vice Chair. Oh, apologies, Vice Chair, you're on mute.
Sorry about that. In follow-up to Board Member McGuire's question, I just had some additional clarifying questions. So first of all, just to be clear, I'm comfortable with the order, but this is just really a useful discussion that we're having here. And so, looking at how maybe things could have been done differently in this case, or, going forward, for future cases. So my question is, if we wanted to, since this was an enforcement proceeding, if we wanted to bring in the other parties, how would we have done that at the initial filing, or Office of Enforcement at the initial filing, or if a decision was made to change course midway, in light of perhaps maybe more of a willingness to stretch things out, just looking for different process options.
Sure. So I'll defer to the Office of Enforcement on most of that issue, except to say that one, because it's largely up to them, right? I mean, they decide what goes in their charging document. We don't, at the AHO, don't get to go tell them, hey, you really should bring in these other parties right now. But in my personal view, they can do that at the outset of the case. They can also, react to what's happened in the hearing and change course as appropriate. I think they have that discretion and flexibility to bring new complaints, charging documents, draft orders, whatever you want to call them. And I will say that I don't want to seem like I'm criticizing the prosecution team here, because this hearing happened almost 8 years ago, and now there's a proposed order, and we're identifying these issues and talking about them. So I don't want to suggest that the prosecution team should have done this in a different way ab initio 8 years ago. I do want to suggest that in addressing the concerns and questions that are being raised, that they do have the discretion in future proceedings to change course in that way.
Sorry, Vice Chair, you're on mute again.
Thanks for the reminder. If the case started as waste and unreasonable use, but bringing in others where presumably there's not evidence of waste and unreasonable use, but maybe it would be, more through public trust. I guess that's where I'm having some challenges. Could it switch over from waste and unreasonable use over to a broader adjudicatory proceeding on public trust?
I appreciate the question. I think I probably shouldn't comment so specifically on procedural mechanisms for bringing these cases before us beyond the thought that I think there's probably an ability to do that.
Looking to Ms. West if she wants to go ahead and address the discussion. And thank you, Ms. West.
Good morning again. Yeah, I just want to talk to the hypothetical, not about this order. And just on the hypothetical, I just want to remind the board that, and just for purposes of this discussion, that we were not adjudicating the rights of this party. We did not validate their rights. And if we would have brought in 2 other parties, it would have been first step would have been, we probably would have had to withdraw this complaint, bring in the other parties and address whether or not they have their water rights claims are valid to begin with before we went down the road of the rule of priority and how we would implement a minimum flow. But it would have been a much broader case with a different set of evidence and a number of different questions. But Nicole's joined us too, so maybe, I don't know if the AHO hearing officer has an opinion on that, but I don't think we could have added parties once this proceeded. We would have, I believe we probably would have had to withdrawn the complaint and alleged it as not only a waste on unreasonable use, but then broader than that, to bring in the other parties and bring in additional new evidence and look to validate their claims of right on a level which this proceeding didn't involve. But
that's really helpful. Thank you.
Yeah, thank you, Vice Chair. Thank you, Ms. West.
And I would like to just weigh in for just a moment, Chair Esquivel, if I can. I think what you're seeing is one of the challenges that we often have. And again, I think Hearing Officer Bevins made this point. This isn't to criticize the enforcement team. There are so many judgment calls that go in, both in terms of what's feeding into the water board system from concerned conservation groups, from downstream diverters. And a call needs to be made at some point in time about, do we want a narrow proceeding that we can move and on grounds that help advance the overall state of California's water rights system. For example, this board has issued some very important precedents, and this would build on that universe, talking about waste and unreasonable use. They're incremental decisions versus bringing more comprehensive claims that bring in other parties. And it's very hard when you get to the tail end of a proceeding and you've got parties who want broader claims to be addressed in them. It's simply a function that these adjudicative proceedings are important, but they aren't always the best vehicle and vessel to resolve some of these types of issues, which gets back to the point that had been raised both by the board and Mr. Bevins has talked about there are lots of tools outside of the adjudicative proceedings that help solve some of those problems, because it can really bring the full panoply of authorities to bear. And what I'm talking about now is quasi-legislative actions, potential in-stream flow actions. They raise their own issues. They do have some transactional costs, but they open up a larger universe for the board to consider and let you look along the larger stream system.
Thank you. Did you want to have
Ye-
further comment?
Well,
Board member?
just I just feel like that this, again, super helpful discussion on all this, but it does to me feel like, you know, that isn't a feasible option. Realistically, like you've got to bring in every party and adjudicate all their water rights. That sounds like not and I understand the I'm worried that we're setting a standard here that makes this an impossible tool to use. And in de facto means that we can't protect in-stream flow. And so I just want to continue to highlight that even just this discussion to me makes me feel even more concerned on that, to be honest. I just think that it means the only way we can staff, it seems like it really limits our ability to consider public trust in these proceedings if we have to step back and adjudicate everyone's water rights and bring in every party on the system.
So I certainly appreciate the sentiment, and it is a complicated issue. I'll just go back to what Mr. Loffer pointed out about, the exceptions to the rule of priority and the ability to make findings about the feasibility of bringing in all those parties. We didn't have the evidence in this one to make those types of findings, but it's certainly, again, not impossible to circumvent in future cases.
I just want to make sure I caught what you said because it was a little quiet. So you're saying, can you repeat it? I don't feel like I caught that response, and it seemed really helpful.
Yes. So, and this just alludes to what Mr. Loffer brought up a few minutes ago in terms of the order's discussion of the rule of priority. There are ways to circumvent the rule of priority in cases like this one. Justice Roby lays out some of those factors, and this hasn't been fully developed yet by the courts or the state board. But Justice Roby lays out some of those factors. One of them, in my view, is the feasibility of bringing in, all the parties to an adjudicative proceeding. And so if a showing can be made, and it wasn't in this case, and I suspect it's because people hadn't necessarily thought about this in this level of detail 8 years ago. But, if a showing can be made, you can, the State Water Board can make findings about feasibility that would allow it to circumvent the rule of priority in particular situations. Or I should say, not circumvent the rule of priority, circumvent a strict application of the rule of priority.
Thank you.
Yeah, much appreciated. Really appreciate this discussion. And again, it does highlight some of certainly our limitations in trying to comprehensively address these issues in AHO proceedings here. But at least, appreciate the pointing out of the El Dorado case and ultimately, some flexibility that is there that we can better explore. And I think it's certainly something I'll be taking a look at. So I appreciate that. Okay, we do have about 9 commenters. We can get to them, and then I'm sure we'll have likely some additional board discussion here. First, I'd like to call up Ken Petrozelli from the prosecution team, be followed by Barbara Brenner, and then Conrad Fisher.
Good morning, board members. My name is Ken Petrozelli. I am an attorney with the Office of Enforcement. I represent the prosecution team. We appreciate the changes made to the proposed order that adopted our recommendations. They will make implementation clearer. We support the order as proposed and recommend its adoption. As for the respondents' recent comments about the cost and difficulty of installing diversion control and measurement devices, they made these arguments before, and the proposed order addresses those arguments. The board's measurement regulations have been in effect for several years now. We enforce those regulations, and they apply to the respondents just as they do to many others. The respondents assert that the location and character of their point of diversion make a measurement device infeasible and prohibitively expensive, but the regulations have alternative compliance plans for addressing these types of challenges. Challenges we routinely work with diverters to resolve. Nothing the respondents have said exempts them from complying with these regulations. As for the respondents' diversion control, the proposed order merely requires them to limit their diversions to amounts reasonably needed for beneficial use, and that they install a control mechanism capable of doing that. It says nothing about what kind of mechanism they must choose, so they can choose the alternative that works best for them. They just need to control their diversion, because no diversion should operate in a manner that is wasteful or that allows waste discharges or channel dewatering at the expense of threatened species or senior rights. Just like measurement, nothing exempts them from these requirements. Thank you for considering this order. We recommend its adoption. I'll take questions if you have them.
Thank you, Mr. Petrozelli. Appreciate the work on this. I don't have any direct questions. I don't think folks do either here, but just thank you. Really appreciate the work. And
Welcome.
thank you. Next, I'd like to call up Barbara Brenner, be followed by Conrad Fisher, then Nathaniel Kane, and Margaret Towser.
Good morning, almost good afternoon, board members, board chair. This is Barbara Brenner on behalf of the Marble Mountain Ranch. And I just will briefly note, and I appreciate all the comments and focus on the public trust resources in this case. And I'm just going to note what Mr. Bivens indicated. The channel of Stanshaw Creek that seems to be the focus of attention, number one, there's no evidence of any interference or harm to any public trust resource within that channel reach. Two, there's no evidence of a dewatering of that channel reach on any kind of ongoing basis as a result of my client's diversion efforts. So I think there's the wrong picture being seen by the board members in that regard. My client is not dewatering any portion of the Stanshaw Creek. The only time that you'll see that occur, under my understanding of the facts, is during firefighting. And they do use Stanshaw Creek for firefighting purposes. And in fact, they will use some of my client's water in storage for firefighting. And I also want to note that that occurs more often than you may think. It's not a once in a while thing. It's all too often given the constant climate change that we're experiencing. I also want to note that this is a very small family-run operation, and the enormous amount of cost this process has taken my client and has endured has pretty much come close to putting him out of business. So when we balance, we need to remember to balance when we're talking about public trust. And how do we do that, I think, is very important for this board to consider. It's not just fish flows. The public trust doctrine goes way beyond just protecting fish. So I just want to note that. My last note is we're not talking about failing to comply with any diversion provisions or gauging the station gauging, or we're saying it is simply not practical or feasible to put any type of measuring device on the side of Marble Mountain where Stanshaw Creek comes down. So it's simply, and we'll work with staff as we have been for many, many years on resolving this last issue with regard to the diversions, but you can't place a device on the side of a mountain that has flashy creek flows that'll simply wipe the entire facility out. You'll just simply see it go down the creek. So it truly is impractical request. And with that, I would appreciate the efforts of the prosecution team. I've worked with Mr. Petrozelli over the years and appreciate that ongoing effort that we've had, and hope and assume they'll have the continued cooperative effort on implementation of this order and reasonableness that really needs to apply in this instance. Thank you. I appreciate your time.
Thank you, Ms. Brenner. Appreciate yours and here representing your client well. Thank you. Appreciate it. Yeah, we have a question from Board Member Firestone.
Yeah, sorry. Thank you. Super helpful, and thanks for your time and work on this. I'm just curious, the prosecution testified around alternative compliance, and so I'm just interested if there have been conversations around what that means and what options might be. And I don't know if that's a question for the prosecution rather than you, Ms. Brenner. But if you have anything to say about it, Ms. Brenner, if you have had conversations on it, otherwise I can ask the prosecution.
There have not been recent conversations
Okay.
with that in that regard.
No, I believe the most fair answer is that we wanted to see what the order would say or require.
Yeah. And could you give a little more information about what alternative compliance means in the regs, or what that is?
So off the top of my head,
Yeah.
the current regulations allow for something for what we colloquially refer to as Senate Bill 88. Those were regulations that the State Water Board adopted to implement legislation that was adopted to require measurement of diversions. And the regulations allow something called alternative compliance plans, where in normal instances, installing a device at the point of diversion might be prohibitively expensive or impractical. So there's flexibility within the regulations to allow for the measurement of diversions. So there's a lot of room to work. And at this point, I think we had to see what the order would require before going farther, because, what diversion will they be measuring? So we would need to see that. And as we get proposals for compliance actions, we can make further considerations and, work with the diverters.
Thanks.
Thank you. Thank you again, Ms. Brenner. Thank you, Mr. Petrozelli. Next, I'd like to call up Conrad Fisher, be followed by Nathaniel Kane, then Margaret Towser and Angelina Cook. Apologies, Mr. Fisher. I think the mic may be off, if you don't mind. Thank you.
Better? Yeah. Okay.
Thank you.
So the portion of the stream we're calling the anadromous reach is from the highway to the Klamath River. My home is where Stanshaw Creek meets the Klamath River. The bypass reach from the point of diversion, allowable bypass reach, allowable by the proposed diversion, is from the point of diversion to Highway 96. That's incredibly long. And Marble Mountain Ranch is not in the Stanshaw Creek watershed. It's in the Irving Creek watershed. So just a few points of reference. And then if you are a salmon swimming up the Klamath in most summers and most times a year when there's not enough oxygen and it's warm, these creek mouths are incredibly important. So the quantity of cold water that enters the Klamath from these streams matters a lot. And I've seen it with my own eyes. You can see the adults gasping for air. And juveniles spend coho need to spend a full year in the pool at the mouth. So coho that are born elsewhere use this stream. So this is relevant when we're talking about water. The history I'd like to share, Mr. Bivens spoke about some things as if they're in the past tense, but they're actually, or as if they could happen if this was implemented, but they've already happened. So from 1995 to 2016, about 90% of the creek was taken out for hydropower and sent over to Irving Creek. That stopped about halfway through 2016 when the Water Board staff compelled Marble Mountain Ranch to stop diverting for hydro. Since then, they've kind of gone in a different direction. So that is the time at which the stream started having more water. So the fish have kind of been not dying since then, but more flow would still result in more habitat. So since then, I've been able to hear the stream from my porch. So the change Mr. Bivens talked about where there would be more water if this is implemented already happened. So I'm hoping to keep that. And Marble Mountain Ranch has shown that there are reasonable alternatives to produce electricity that don't require any water. So there's a possibility for a resolution to this. Maybe they would even concede to it if somebody asked. Since the Water Board staff compelled Marble Mountain Ranch to stop diverting for hydro, about 2/3 of the creek have been making it to the mouth. So that's a tremendous improvement, but still about 1/3 of the creek being taken out that's not being used is not necessary in this case. So a few things in addition to the hearing that took place in 2017. It was a 4-day hearing with a different hearing officer. That's also the year of the Marble Fire. So there was a fire that started at Marble Mountain Ranch that year. So that changes a few things with regard to flows and what happens during floods and how often the ditch washes out. So I just quickly want to go over 4 key asks. And I don't honestly know, given what options have been put out there, the best path forward is. If remanding is the only option, I guess that's what I'm asking for. I hope there's other options, but yeah, as it is written, I'm going to go over these 4 issues, the top 3 of which have already been addressed by other comment letters and generally supported. So the NIMS bypass flow recommendation, as it pertains to non-consumptive use, we shouldn't need site-specific information to know that dewatering a portion of the stream from what you see on this map, point of diversion to the highway, is harmful. It's kind of universally true, but nonetheless, there is plenty in the administrative record, including the recommendations from CDFW and NOAA Fisheries about what would happen, including the production of food and impacts on water quality. So putting the entire creek in a pipe, or most of it, from the point of diversion to the highway is kind of ridiculous and unnecessary. So the other reason the NIMS bypass flow is reasonable and necessary is because, and I think this is missing from the entire morning discussion, we can focus on justifying what the fish need, but this is one of the rare cases, unlike the other water disputes, where if we only focus on what the humans need, myself and Marble Mountain Ranch and the third person up in the watershed, we can all have our needs met with less than 10%. So the fish could get what NOAA Fisheries has deemed and what the Richter study deemed highly protective without even cutting into our consumptive need. So I'm going to get into my second ask, which is, I'll get into the water numbers, but let's actually implement this in such a way that you limit what's taken out of the creek to what is actually needed at the place of use. So for context, what the creek provides in the summer at the point of diversion, up above the point of diversion, is between 2 to 3.2 CFS. So that's actually what's available. The need, according to the most objective analyses by the Water Board staff in the past, was 0.102. So 2 low in the summer, 0.103 is the need. According to the draft order, the need maxes out at 0.24. So based on Marble Mountain Ranch's statements of diversion and uses, they've been taking 0.75, which is 3 times the highest amount allowed by the proposed order. And I'll get to why I think this is. And also, assuming the statements of diversion and use are true and the Water Board's estimates of need are correct, 0.1, then that diversion has been 7 times the actual need at the place of use. My letter that I've shared with you talks about these different percentages, but the difference in those two is the difference in 37% of the creek and 5% of the creek. So it's a very big difference. I believe one of the main reasons this is happening is because the method of diversion precludes the ultimate goal of this proposed order, which is to limit the diversion to the amount needed for beneficial use. Having a massive diversion ditch may have been appropriate when there was hydropower going on, but for just the amount for consumptive use, it's overkill. I've tried to think of some analogies. One is it's like using a semi-truck for a DoorDash delivery. This issue has come up in the Scott Valley where we're talking about diversion ditches just to give water to cows. It's overkill. It's impossible to regulate based on the amount what is actually needed with a big ditch. It's just not the right tool to get the water to the place of use when we're only talking about consumptive use for a limited amount of structures. The solution I know about is putting the water in a pipe. This is what I do. This is what the upstream diverter does. This is what most people in the area do. So if you think about how we use water in the cities, you turn on your faucet, the water flows. You turn off your faucets, the water stops flowing. That's exactly what I do. And that's one very reasonable solution that could happen in this case. The water will not come out of the creek if you turn off at the place of use. So this is where in the proposed order, just merely saying must have control at the point of diversion might be interpreted to limit the best options. So I realize that the board doesn't want to be prescriptive here and say thou shall use pipe, but I'm hoping you will say thou shall, to me and the other water users, thou shall limit your diversion to what you actually need. So again, to solve this, let's focus on what the humans need, because then we will come to a solution that gives highly protective flows to the fish. It's not possible elsewhere, but it's possible here. A few other reasons the method of diversion is unreasonable, and this is in the administrative record. It washes out in the winter. The pictures that have been shared with you, there's plumes of mud going into the Klamath River in the winter. It also happens in the summer when, if you're diverting using this ditch, if Marble Mountain Ranch is, to maintain their system, they occasionally in the summer have to turn the ditch off. What does that mean? If they're diverting 90% of the creek as they were in the past, the flow comes up and that bypass reach carries more mud down. So the plumes of mud happen in the summer as well. So this is another issue that could be solved if we had a reasonable method of diversion. And finally, the issue of water for fire suppression. The draft order says periodic use of up to 3%. No party has presented evidence or argument that periodic use of up to 3 CFS for firefighting is unreasonable or has unreasonable impacts on public trust. First, this issue of balance against the need for fire suppression. If Marble Mountain Ranch took 3, there would be nothing downstream for fire suppression at my house. In 2017, during the Marble Fire, there was enough water on both properties because he was not taking 3 CFS. If you look at my letter, you'll see that 1 CFS alone would be enough to fill 232 2,000-gallon fire trucks every 24 hours. So 1 is more than enough to achieve that purpose. But it's not just about that. Having water in the creek also gives firefighters options at the Highway 96 crossing. When that fire was being suppressed, that was going to be an option if the fire crept into my land. So having all of it go toward Marble Mountain Ranch precludes fire suppression elsewhere. Also, it's not necessary. 1 is more than enough. And then third and finally, impacts on public trust. No evidence that taking 3 CFS out would harm public trust. I'm sorry, that's the entire creek. How could it not? Periodic use, Marble Mountain Ranch hosts fire camps. So this could be almost every summer if we're talking about hosting fire camps for filling up trucks to suppress fires elsewhere. And I'm not saying that shouldn't happen. I'm just saying it needs to happen with a reasonable amount of water that doesn't dewater the stream every summer or impair my ability to fight fires. During the Marble Fire, I think I mentioned there was enough water. I was able to rent a pump, put it in the creek. Firefighters said, if it creeps onto your land, we can use the stream on your land. So it doesn't have to be all one or the other. I guess as many of you know, the Mono Lake case says harm to public trust resources should be avoided or minimized if feasible. In this case, it's very feasible to have high level of protection, 90% unimpaired flow, and still meet all the needs of the out of stream diverters, myself included. So let's focus on actual need at place of use, as opposed to fish need this much, humans get the rest regardless of how wasteful they are. This is unique in that situation. So it is feasible to implement the 90% unimpaired flow. I would be one of the 3 water right holders supporting it. So I guess, yeah, in closing, I don't know what the best remedy is, but adopting this as is would harm the bypass reach. It could have basically no bypass flow recommendation. The 90% is justified. There is plenty of site-specific evidence from the Karuk tribe, the U.S. Forest Service. There have been fish counters at my house for years. There is plenty of evidence that went into that recommendation. And most importantly, we can give a high level of protection without impairing human uses. If there's any questions, I'm open, but I would really love to resolve these issues. I've been at this 30 years, to resolve them in a way that provides a durable solution.
Thank you. I really appreciate you being part of the proceeding here, Mr. Fisher. Certainly as a property owner and water right holder within these watersheds, really appreciate your engagement for sure. When it comes to the four, items or things you've requested changes, I feel by and large, number 2 and 3, we've kind of here attempted to address, and here I know understanding you feel doesn't go far enough, but at least with, again, the direction to put into place method of diversion here so as they can control that, and then ultimately trying to limit them actually to what their reasonable use is. And, again, it's not quantified certainly through the proceeding, but we're hopeful that has the effect of at least accomplishing a couple of the things that you're looking for here. I know we've had a lot of discussion on bypass flows. I'm sure we'll have additional discussion here and on the fire suppression side of things. And I think those are the two that, again, we're not necessarily entertaining here, but do acknowledge that, there are concerns around both. So just thank you, Mr. Fisher.
Okay, as remedies, I would really love us collectively to explore what they are. Remanding it would be, we're going back to a black box of where we can't actually discuss these things, because many of these conclusions have been based on things that are just simply not true. But having conversations might make it more productive. So I don't know. Thank you for your time.
Thank you as well, Mr. Fisher. Yeah. Next, I'd like to call up Nathaniel Kane, be followed by Margaret Towser, then Angelina Cook and Matt Thomas.
Good morning, afternoon, members of the board. My name is Nat Kane. I'm speaking on behalf of Environmental Law Foundation only today. I just want to make a few quick points. I support the proposed order here in general. I've looked through the file in this action, and this is the kind of action that I would just love to see this board do more of. The board is using its regulatory authority to protect public trust resources, and that's the job. So it's really good to see this kind of action being taken. And then, we've seen the diverters here potentially in response to this proceeding have begun to move on from the early 20th century technology that they were using for power generation. And it's my understanding that they now have solar with battery backup on their property, which is going to really help out with power generation without the kind of negative externalities that come from using an outdated hydropower system. So to me, that's a win. It's a win for fish, and I think it really is an example of water rights enforcement moving the state forward. I do think that the board could take a second look at the bypass flow issue. I know it's been extensively discussed today, but I am worried about the precedential issues that have been raised. I don't want to see the board boxed into a position where the evidentiary showing required for a bypass flow is much higher than can reasonably be accomplished in this kind of proceeding. I know this has been discussed a lot today, but I do think that general principles about the need for bypass flows can be applied to specific streams. And I would love to see some sort of analysis or language in the order that can allow for that in the future. I also support the comment by Board Member Firestone that outside of firefighting issues, dewatering a stream is not consistent with the public trust in general, given the facts here. I'm also just interested in seeing how these types of proceedings can be streamlined in the future. This proceeding has been going on for a very long time. It's surprising to me that this is the first time, as Board Member McGuire pointed out, that the board is actually potentially stating that it's enforcing its public trust authority through the water rights enforcement process. And I know that various things have slowed this down, but and I think the point the petitioners, the respondents made was important, that transaction costs are real, and that's true for diverters. It's true for members of the public, and I'd love to see more of these types of actions moving the state of water conservation, water rights enforcement forward, but hopefully figuring out a way to make it more streamlined, less costly for everyone involved. And then I also just wanted to mention that I think a lot of the discussion among board members has just been really fascinating. I think there's a lot of important procedural and legal issues that are being raised by this that we're looking forward to working with the board in the future on. So thank you for the opportunity to comment. And that's all I have.
Thank you, Mr. Kane. Appreciate those comments and contributions here to the discussion. Next, I'd like to call up Margaret Towser, be followed by Angelina Cook, Matt Thomas, and then Regina Chickasola. Hi, Ms. Towser.
Morning. I'm here.
Good afternoon. Thank you.
Good morning, or good afternoon. Thanks for letting me speak. My name is Margaret Tauser. I'm a retired hydrologist from the National Marine Fisheries Service. I've been working on this project for quite a while before I retired. I'm here today to express some concerns about the draft proposed order and maybe some clarifications regarding the Marble Mountain Ranch water diversion, and to ask for a change in the final order. I have two main requests. First, the bypass flows. I think they should be included. The final order should include the bypass flows that NIMS and the California Department of Fish and Wildlife recommended. This will help protect coho salmon, which are listed under the Endangered Species Act. The 90% request would protect the natural variability of the hydrograph. Using this high-level bypass flow with a 0.24 CFS or less than would allow higher than 90% bypass through much of the year. The high level of protection could allow some diversions from other users without significant increase in percentage or impact to the ecology. What I want you to understand is that the main reason for the 90% bypass flow recommendation, aside from being highly protective, was that it was possible. It allows Marble Mountain Ranch to get their full consumptive water right. The bypass flow study was simply used to demonstrate that the 90% bypass flow could be accomplished in this case. The second point and request was to provide a limit to the Marble Mountain Ranch's water diversion. The amount of water that the Marble Mountain Ranch can take should be limited to no more than 0.24 cubic CFS, which is all they're asking for, I believe. According to the requests, it seems like a generous amount, but this may mean that they will need to use pipes for their diversion to meet that requested amount, so they don't have the ditch losses. To explain the first request about the bypass flow requirement, the proposed final order does not include a bypass flow requirement at all. NIMS and CDFW recommended that they leave at least 90% of the unimpaired flow in the anadromous reach of the creek and a minimum of 2 CFS in the non-anadromous reach. Even with this bypass flow, the non-consumptive diversion could occur most of the year in the times when needed. Without the bypass flow limitation, the stream could be completely dewatered if the non-consumptive diversion is resumed, since the natural stream flow can get to those low levels that are equal to the same amount of the requested diversion. A stream cannot be dewatered and protect ecologic continuity and public trust resources. This recommendation is based on a lot of site-specific data, even though the letter said it wasn't. That included topographic survey of the stream, flow measurements in the stream, and a full hydraulic model that demonstrated that 2 CFS was the lowest flow in Stanshaw Creek, where the stream flow remained connected throughout the stream. It's not so it's very, very shallow but connected. The goal was to protect coho salmon while still allowing Marble Mountain Ranch to take the water they need. And why I think this bypass flow is reasonable, the analysis was thorough, looking at multiple nearby stream gauges and flow measurements. The results showed that Marble Mountain Ranch can meet its consumptive needs up to 0.24 CFS in all but the driest years, as long as there is a 90% bypass flow. This is an opportunity where fish could have a high level of protection and the users can have the water they would like in an affordable way. On the use of the ditch, using the ditch to carry the water would result in a lot of waste due to seepage and evaporation, potentially tripling the amount of water needed. A pipe would be a more efficient way to carry the water and could help ensure that Marble Mountain Ranch meets its water needs 100% of the time. It would also make it easier to monitor and maintain the diversion. It'd be small enough to be affordable. If Marble Mountain Ranch returned to using the larger non-consumptive diversion for hydroelectric use, they could continue to use the ditch as long as they maintain a 2 CFS minimum bypass flow. Anyway, those are my points. It feels like you could adopt the bypass flows and still meet all of the issues in the order. So I'm happy to answer any questions you might have.
Thank you, Ms. Towser. I do appreciate your contributions here and your expertise, importantly, as well. And just points well taken. I think here, it's not around the merits of a bypass flow for the system that the board isn't considering it. It's really here a procedural issue at this point, and being able to simply, at this moment at the dais, be able to accomplish that. But nonetheless, I do appreciate your expertise, your feedback and contributions to this discussion. It means a lot. So thank you. Yeah, Board Member Firestone, please.
Thanks. And maybe this is for Mr. Bivens, but just just to clarify, are we, this order's limiting them to consumptive use? Or are we allowing non-consumptive use? I thought we were limiting them to consumptive use.
No, this order allows non-consumptive hydropower diversions so long as the water that is not used consumptively is returned to the stream above the anadromous reach.
Right. Okay. Okay. Thanks. Thank you.
All right. Thank you. Next, I'd like to hear from Angelina Cook, be followed by Matt Thomas, Regina Chicazola, and then our final commenter will be Castle Willie.
Good afternoon. My name is Angelina Cook, speaking on behalf of California Sport Fishing Protection Alliance. I appreciate listening to all of the details behind this decision. It certainly illustrates my prior comment about how difficult efficient enforcement really is. To encourage inclusion of the bypass flows, which it sounds like is more of a procedural consideration at this point rather than one based on merit. So I'm not sure if I have anything to offer at this point, but I guess what I want to say is the public trust doctrine, the considerations of the public trust and maintaining habitat for conducive to support the coho, I feel like is of higher priority than the issue of the prioritization of rights. So I would just love to see the board move forward in a way that demonstrates prioritization on recovering our threatened and endangered fish species, which is, this is just one tiny little example of where the board really can assert its authority to prioritize conditions conducive to salmon recovery, despite the realm of complicated procedural framework in which you have to operate. So thank you very much for this opportunity to learn more, and I and for listening to my comments.
Thank you, Ms. Cook. I do appreciate those comments, but incredibly imperative that this board does act according to the law. I think in a time where, we see the importance of adhering to that, even though, again, it can pose some challenges in being able to cleanly address some of these issues. We have the legal framework that we exist in. And so, but nonetheless, really do appreciate your comments and advocacy, Ms. Cook. So thank you. Next, I'd like to call up Matt Thomas, be followed by Regina Chicazola, and then Castle Willie.
Hello, my name is Matt Thomas, and I'm with Stream and Civil Engineering. And I would like to, I think a lot of the points have been great today and cover a lot of issues. And I just want to specifically talk about the ditch, kind of the issues that around the ditch in its current configuration, and then also speak to the benefits of what a piping the ditch could do to the whole watershed. So first off, the ditch is the conveyance capacity of the current ditch, was originally built to convey nearly 15 CFS, which so it's extremely oversized for what the current conveyance requirements are. And the National Resource Conservation Service soil survey indicates that the slopes of the Stanshaw watershed and the soil types that are present there are not suitable for forest roads or for constructing forest roads or trails. And the ditch in its current configuration, for all practical purposes, is very similar to a forest road. And the reason why that is when the ditch was constructed, it had to over steepen the slopes on both the uphill side and the downhill side from the current 1.5 to 1 slope that is the natural slope to a nearly vertical slope, and which causes slope instability, which then leads to fine sediments and then reaching the Stanshaw Creek. And in a inspection done by the Regional Water Quality Board in 2015, which precedes the Marble Mountain fire, they identified 19 locations of the failure of the ditch, all creating sediment sources for Stanshaw Creek. And then I think everyone here can recognize that the fire in 2017 has only exacerbated those failures and sediment supply to Stanshaw Creek. And the current configuration, there is no way to control the amount of water that is diverted in from Stanshaw Creek. It's the way they have it constructed based on my visual inspection is that it's almost kind of an all or none way that they've configured the inlet to the ditch, just because of how steep the creek is in this location, how dynamic it is, lots of changes in the bed there. So a actual constructed diversion point that could control the amount of water diverted would be beneficiary, and a pipe would only would make that even more practical and probably more cost effective as well. So and then the other thing a pipe does is it basically eliminates all infiltration that currently occurs in the ditch, which is in a watershed that has limited water supply. Every drop counts, so eliminating that infiltration could be of a huge benefit to just the water, not only for consumptive use, but then also for the bypass flows. It also increases the stability of the hill slopes, reducing sediment supply to Stanshaw Creek, which in turn improves water quality. And then another key aspect is that it would virtually eliminate any required maintenance of the ditch. Right now, I would assume that there would need to be annual maintenance that occurs on the ditch, and if that is not done, then the failures can be, will of the ditch would increase exponentially, creating that much more sediment supply to the creek itself. So, and that's about all I have to say. Thank you for your time.
Thank you for yours as well, Mr. Thomas. I appreciate your comments here and contributions. Looking to Board Member McGuire.
Yes, thank you, Mr. Thomas. And I just wanted to say I appreciate the analysis that you provided. Engineer myself, and I took a look and I was really trying to understand, because we've heard a number of times concerns about the feasibility of installing a diversion structure and measuring the diversions and the merits of piping or not piping the ditch. And I'm comfortable with the conditions the way they're written on this item in the order for now, but I think you raised a lot of good points that the water right holder could consider in the future. And I certainly think it's possible, although not easy, to construct a measuring device and appropriate diversion for this facility, in my opinion. So I just wanted to plus up some of the findings that you shared in your analysis, and thank you for the contributions.
Thank you, Board Member. And thank you again, Mr. Thomas. Next, I'd like to call up Regina Chickazzola, be followed by Cassil Willie.
Oh, oops. Hi, my name is Regina Chickazzola. I'm actually speaking as an individual resident today, and I want to make that very clear. I've actually lived on Stanshaw Creek, and I've lived in the area surrounding it for many, many years. So I'm not speaking as Save California Salmon at this point. And I just wanted to point out a couple things. This is a very small watershed with very few water users. However, it is really critically important to coho salmon, and they do not have much refugia or habitat at all in the Mid-Klamath River because of the steep landscape. So I just wanted to point that out. This is not like the Scott Valley, where there's really good habitat all over the place, or lots of water users. I also wanted to say, that I really like the people from Marble Mountain Ranch. They are reasonable people. I can't say if they've always been that way, but recently I've found them to be good community members and people. And I just think, it's important to say that both them and Conrad Fisher are nice, reasonable people, who have been my neighbors, and I really respect them all. And I think if there is a place where people can work these things out, it could be this creek. On that, I would like to also say that the ditch I find to be extremely unreasonable and not the proper tool for this landscape. I do think a diversion control device on this ditch is probably not going to work, but what could work is most of us who live in this area have a pipe. And they do have a good water supply. And so it's very feasible for them to have either a buried poly pipe or even metal piping. They might even be able to get financial help from a Fish and Wildlife Agency, being that there's so much water savings in that situation. This is an area that is so steep and full of landslides, full of fires, and having a ditch that is meant to convey that much water is just not very reasonable. Also, I wanted to say, I think that the water board understands the way the weather is here, but the perfect situation for power generation, and this is a part of the river I've lived on where there is no power available, but the perfect situation for power in this area is actually to have summer solar and winter hydro, because, it's a flashy type of water system, and they have put in solar. And so I think in this situation, we could have it where maybe they have different diversions at different times a year, especially if they did have a pipe with an on and off turn off, like most people in the area do. And like I said, I do feel they're reasonable people and they'd be possibly willing to do this. On the issue of fire, it's true, fire is constant in this area. I've had 2 fires by my house, fires near my house 2 out of the last 3 years. I think they have more frequent fires, truthfully, in this area. But I do know the best situation for fires is above ground storage. And I'm not talking about dam storage. Like I said, this is a small area, just having just water tanks. But, you know, in the situation for human safety and fire, I'm sure there could be wording in there that could just deal with this. But the way that it was set up, and, you know, probably Doug and Heidi didn't set it up this way, was meant for a different time when there was different water. There wasn't the concerns of coho salmon, and it is very reasonable for the downstream water users, including tribal users of salmon, to want water within this creek, and to want the coho to be able to thrive here. And it's not just coho either, it's also critically used refugia for tribal trust species. So with that, I just wanted to say also, I've really enjoyed this conversation. I'm really glad we're talking about the engineering of the ditch. I'm glad we're talking about what the authority is in this situation, and the fact that bypass flows is actually really reasonable and could happen in here. Like it's kind of like how I bring up on the Smith River, where there's not many people. We could work this out. We could work it out in a way that benefits the salmon and does not put an unreasonable burden on the Marble Mountain Ranch. And I do think getting rid of the ditch and doing piping is the way to look at this diversion control mechanism and making sure there's in-stream flows. And then also, you know, when summer comes, maybe they can just turn not only have consumptive use. And if they do have a pipe instead of a ditch, then that's totally possible. But when you have a ditch, you have to be diverting water. And so those are, I think I'm probably at my time, I'm guessing, but I just wanted to say that I really appreciate you moving forward with this. I really appreciate that I've seen the Marble Mountain Ranch like put so much into changing their power system. Maybe they had to do it because of this process, but they are, you know, and I see that they are. But I really urge you to act in the way that benefits the fish and the neighbors in this situation, including them. And I don't think having an oversized ditch system in an area that's extremely prone to landslides and taking water out of one creek and putting it into another benefits anyone. So yeah, I support the bypass flows. And I think that with the needs of having hydro in the winter and solar in the summer, which is how you pretty much have to do it in the rivers, I think it's totally possible to go with those bypass flows and to use piping as a diversion control. Yeah, and I think these are solvable issues, and much respect for all the parties and people who live on the creek. Thank you.
Thank you. Really appreciate those good comments, Ms. Chigazola, and the acknowledgement of folks here, both at Marble Mountain and then others here in the watershed that are working toward all of this. I think important to note as well that, you know, especially when it comes to the ditch and the diversion structure and what gets worked out there, there's opportunity to continue to work on those issues as that's developed. And I think important also to note that this order isn't a ceiling on what is being done and what can be done and what's possible in the watershed on this creek. It is really a floor. And so I think there's, you know, there's what we can do within our authority right now and our work to direct. And then there's, I think, what should be good momentum coming out of this, and especially expectation from this board that the system not be dewatered. But, you know, instead, I think there's a good productive conversation that can certainly stem that isn't necessarily a directive from us, but our order can help set the groundwork for. Okay, next I'd like to call up Casil Willie.
Hi, good afternoon. Just as a caveat, I wrote my comments prior to the discussion today, so some of them are repetitive and may not be valid or relevant anymore. But I wanted to echo some of the comments that were in requests that were submitted in letters prior to this meeting and some comments made today. But I also wanted to note that today's discussion regarding public trust is concerning, and I encourage the board to do what it can to make sure that the public trust is protected. First, I wanted to offer a bit of background as to why this is important to Save California Salmon as an organization that prioritizes tribal communities and the protection of tribal cultural resources, tribal water rights, and culturally significant salmon. So that's just why this is important for us. Stanshaw Creek is a place of great cultural significance to the Karuk people who have lived in the area since time immemorial. Today, the Karuk people still use the water and the land of the riparian corridor for ceremonies, subsistence fishing, cultural burns, and in order to just to continue many of their traditions. Additionally, the creek is habitat for endangered salmon that the tribe has depended on for generations. The proposed order potentially causes a threat to these cultural practices of the tribal community around Stanshaw Creek. And ultimately, before the final order is adopted, we feel there are edits, potential further discussion that needs to occur. So we wanted to request first that the NIMS service bypass flow recommendation be incorporated, that the ranch be prohibited from diverting more water than is needed for reasonable beneficial use, that a diversion control mechanism capable of limiting the diversion to the amount of water needed at the place of use be required, that the ranch be required to share water for fire suppression in the event of wildfire that threatens not only the ranch, but also the Lower Creek properties and surrounding area. And finally, that the ranch be required to transfer its system from the unstable ditch system to a pipe-based system due to potential water loss and failure. That concludes my comments. And thank you for the opportunity to comment today.
And thank you for those comments, Ms. Willie. Good to hear from you and appreciate the engagement here. All right, that brings us to the end of our commenters, but I think we still have here discussion. I mean, fundamentally, what we have before us as a decision is either to approve, deny, or remand, importantly. I think it's not lost on me that, again, this proceeding happened, it's now 8 years plus, and I think that there is a need to move forward, but at the same time, looking to hear from fellow board colleagues to see where you all are and your balancing and determination here, knowing again that unfortunately we aren't able to at the dais here make a further adjustment. So it really is around whether we proceed now or remand. Board Member Firestone, want to kick us off?
Well, I think because I've been raising concerns just to, you know, I will say, you know, I've been listening to the comments and going, and the back and forth was super helpful. Thank you for letting me ask so many questions and super helpful responses. And also just going back over the order, I feel like in this case, it does, it seems like it's, this order would be helpful for moving things forward as is, without having to do a remand. It does seem, I'm very concerned about our ability to set bypass flows and consider that and how we can, you know, this is an overall challenge, but, you know, for example, this has been said, this is a tiny, relatively tiny watershed in our state with just a few users. If we can't do it in our consideration here, I'm just worried about, you know, where we can, and that it's never going to be, we're never going to have enough resources and time to make that a priority, and it's going to leave rivers without protections that they need. But I also, the reason that I am more, you know, that I am open and, you know, interested in other board members' thoughts, but I'm open to not, you know, remanding and reopening this here is because it does seem like at this, you know, this has been a long time coming with this. There's a lot of changes in cooperation. There's not kind of what seems to me an imminent threat of this right now, given that there's, you know, they've changed the diversions, and it seems like there's a pathway here and the importance of having, allowing for that collaboration to move forward and not just keep a proceeding open for a decade or two, is important. I think we do need to be able to move forward. And I also think that the precedent of clarifying in a decision the application of public trust with unreasonable use is a really important step that we should take the opportunity to do as well. So, you know, I think that's where I'm landing on these overall. I remain concerned about the issue. I remain concerned about, you know, can we, how do we address dewatering and within our adjudication process. And you know, I don't think I made this super clear, but I think also Ms. Lilly brought this up, but I think a real challenge in the adjudicatory process and the regulatory process, but especially the adjudicatory process, is, you know, consultation and incorporation of tribal interests, and being able to consider that within records and decisions and get information on that as well. And I just think in general, that's an area I'd really, the Administrative Hearings Office and overall at the Water Board, we're really trying to evolve and think about how we can improve. So you know, I think that's not very satisfying, but it's kind of where my mind is right now.
Appreciate that, board member, and likewise have concerns here, ultimately with our ability to expeditiously be addressing the challenges that are facing so many of our watersheds here, and provide and put protections into place. And again, I think this conversation has been very helpful because I hope what folks are hearing is more of an expectation that as we have enforcement actions, as we take these opportunities, if it's, you know, even if it's not right, but if it's, you know, looks like it is reasonable, and not just reasonable, but could really advance the need to provide protections, have in-stream flow on a system to use the enforcement side of things, but importantly the AHO as well, to advance those and make that clear earlier on in the scope of what's being advanced. And I think, though, that you know, definitely want to leave a lot of discretion to our enforcement folks. You know, we depend upon your leadership and expertise to know the right path. But I think that trying to be a little more expansive at the front can help really scope out some of these projects in a way that, like this moment, we might find ourselves with having to, you know, a benefit to having extended the discussion a bit more, whether that's including additional water right holders within that watershed, or here again, looking at the El Dorado decision and some of the ways we can not have to expand to all water right holders perhaps, but still yet get some bypass flow or in-stream flow work done. So just thank you. I appreciate, I know the discussion we've all had and the consideration here for this item. Board Member McGuire.
Yes, thank you. So at the risk of sounding a little crass, I'm going to try this. And that is that this has taken far too long. And I don't want anyone to take this the wrong way. And I don't mean to say that there's not anyone here who's doing their work as best as possible to get this completed. But I've been spending a lot of time reflecting lately. And one of those reflections is, you know, the fact that I've been on the board a little over 6 years now. And I think I can count on one hand the number of water right enforcement matters that have come to the board. And I suspect that there's probably a lot more out there that warrant action in some form or another. And what we've seen here is actually that the water right holder, through this process, I think, you know, in large part, has been willing to collaborate and willing to make changes to their use of water and their practices in a very positive way. And I've heard that from another number of the commenters today, and that was actually really encouraging. And it's a testament to the effectiveness of our system when it's working. And part of the AHO's, the Administrative Hearing Office's core, the reason it exists, actually, is to expedite water rights enforcement cases. And so it's not, and it was interesting. I appreciated Mr. Lilly's comments on this. And, you know, one of my first conversations I had with him was on this very issue of, you know, how can we move this process along faster and more efficiently and more effectively. And so I just want to thank everyone for bringing this here today. For all of those reasons, I'm comfortable with the order. I think it's appropriate given the information that was presented at the hearing some years ago. But I think our understanding has changed, and I think our priorities continue to evolve, and our awareness of the challenges about how heavy a lift it is to implement protective flows on streams is something we're all very cognizant of. And so I think the discussion has been really helpful for me today, and it's a lens that I think I'm going to be bringing to future matters when they come across that's something that's been considered. And I don't think it's always appropriate. There's lots of beneficial uses of water. And so this is really a balancing. It's not an all or none, right? It's based on the evidence, it's based on the history, it's based on priority. There's a lot that weighs into this, but nonetheless, it's something that's very fundamental to our mission, and I take it very seriously. So I just wanted to echo that and support the other board members' comments on that issue. And beyond that, I'm comfortable with the order as it is today to move forward rather than some other option. Thank you.
Yeah, thank you for that, board member, and agree. I think we look to see continued efficiency within the AHO, and what I've been impressed by is, as each of these cases have come before us, and there is an iteration, there is a lot of improvements ultimately in the way that we're handling things, but agree that, well, prior to the AHO, we really had no resource like it, and so still ramping up, and agree though that we're just here to continue to improve that process and make it and just appreciate the leadership from the AHO to continue to make it a tool that really helps us work through what is a long-standing need on the water rights side to be working through this. So appreciate those comments, board member. Board member Morgan.
And thank you. And just, also just want to echo my appreciation for the conversation today. It's very helpful and really does help with, the future of just where we're looking to go. And, I also just echo board member McGuire's comments regarding, this started, 8 years ago, and it gets really difficult when we do have something come before us that has been around for a while. And, when we look at today's priorities and what we're looking for today, they may not always align with where the board was 8, 10 years, prior. And so it's always good to do those checks and to have these conversations. And it's also, want to express my appreciation with the AHO, where, they're here now to really help us to expedite these proceedings, to really make sure that we're moving through them efficiently. And I believe that will help us to make sure that we're moving through proceedings, especially water rights enforcement activities, to where we are staying aligned with the board's priorities at the time that something is brought before us, so that we're not having to look back in the past and to really try to understand what was the thoughts when a complaint came in, and to just go back in time to rework a case. And so really appreciate the AHO and their efforts to really move these cases forward, bring them in front of us and much more efficiently, and to really understand the board's priorities and where we're moving. I also wanted to appreciate the comments that have been made today regarding just the cooperation within the watershed, with everyone just really working together to achieve a common goal. And, especially Ms. Chigazola, your comments regarding just the Marble Mountain Ranch and their efforts to really get up to date and really being involved in working with everyone in the watershed. And, in light of just where we are today, and just hearing that, while we look back and we look at today and our, we're where I sit today, while perhaps this order may not be perfect per se, I think that we are at a good place to move forward, especially seeing that everyone is willing to work together to really to do what's right and to improve, to put in solar panels, to improve processes, to really take a look and see, how can everyone can work together within the watershed. And so my hope is that this work really is just, it's a starting point, and that the watershed can continue to work together to continue to make improvements. And so, because of that, I am comfortable with moving forward today.
Thank you, board member. Appreciate those comments. And I think then if there isn't anything further from folks, any further points, and again, appreciate the opportunity we've had here for dialogue around all of this and all the participants here within this proceeding. And again, understand folks are wanting us to be able to go further here. I think it really is that balance of moving forward and there are protections here. This does present significant work, if not everything I think that we're looking to see in this watershed. And so just a lot of thanks to folks. And if there isn't further comment, I think we're ready for a motion.
Great. In that case, I will move to adopt the order under item 4 with change sheet number 1.
I'll second.
Thank you both. Ms. Tyler, can you please call a roll call vote?
Board Member McGuire,
Aye.
Board Member Firestone,
Aye.
Board Member Morgan,
Aye.
and Chair Esquivel.
Aye.
Thank you.
Thank you as well. The vote is unanimous and the order is adopted. Again, much appreciation to everyone's work on this, and look forward to actually hearing updates as well as how the order is implemented and how things continue to go on the watershed. So thanks, everyone. Very appreciative of it. Okay, that wraps up then item number 4 and brings us to item number 5, which is board member reports. Looking to fellow board colleagues if they have any. I'm quickly pulling up my own calendar.
I don't have a report.
I do not have a report.
Thank you. I'll quickly just note on Monday, January 27th, I participated in the California Environmental Protection Agency's Tribal Advisory Committee meeting. It's a convening of the committee members, all of the BDOs. We all had time to be able to connect with our tribal partners. Big discussion on tribal beneficial uses. It was also good to be able to update folks on the recent changes with the Office of Public Participation now being Office of Public Engagement, Equity, and Tribal Affairs. And so great to also have Nathan Blacksmith. He's our new Tribal Affairs Program Manager there as well. And so it was a good discussion, and really appreciate always that space and venue and time with folks. And then additionally, I was just going to flag just this yesterday was at the California Municipal Utilities Association conference. Was on a regulator panel along with Chair Randolph from the Air Board. It was good to have air and water. We just needed DTSC or others to have the earth component. And then after that, want to thank folks at the California well, the UC and then also the California Council on Science and Technology. I was part of I was the state rapporteur on a panel regarding climate action on water resources management and drought. And so that was a good convening. Ted Grantham, who's part of the Co-Equal project, was there talking about his project. There was a number of other researchers also talking about the good project work that they're doing on drought and drought management. A lot of commonality and the desire to make sure we're really connecting to communities, connecting to tribes, bringing everyone part of the decision-making process and understanding of challenges on our water resources and how important it is that we have all those voices. It certainly emphasized for us, we well know here at the dais how critical those voices are so that we can actually be decision makers here in our best form, informed by folks most impacted actually by so many of the consequences of climate change. So it was a great convening and appreciated the opportunity. And that's all I have. Board Member Morgan, anything on your end? Okay, thank you. that wraps board member reports and brings us to the executive director's report. I think Mr. Bishop, are you providing a report here in absence from
I
Mr.
was
Oppenheimer?
going to read it, but he told me, no, just to say there's nothing to report.
Thank you. Maybe the reading will be at the next executive director's report. Great. Well, thank you, everyone. Thank you for today's board meeting. This is just a one day. We don't have a workshop tomorrow. We will not be adjourned currently because we will go into closed session. Although I know there were board members looking to attend the staff workshop on the Bay Delta. There's a series of meetings being held. There's one being held right now. It started at 1 o'clock until about 3. We have two options. We can go ahead and do closed session quickly, or wait till 3 o'clock if folks are wanting to, attend that. And if so, we can wait till 3. I know, I believe our vice chair is currently unable to attend closed session anyway, so might make some most sense to just wait till 3. But looking to.
I would
move on.
appreciate that offer if the other board members are comfortable. Waiting till 3 would be work for me.
Okay, yeah, I'm seeing nods. So let's go ahead. We'll plan on having closed session at 3 o'clock. We will just be having a closed session on the Delta Conveyance Project, not on sites or Title VI. And looking to see if there's anything I missed. Otherwise, Mr. Lawfer, our next meeting, so everyone knows, will take place Wednesday and Thursday, February 19th and 20th. So until then, be safe, be well. Thank you all again for today's contributions and discussion. And we'll be going to closed session at 3. Thanks, everyone.